21 is the part matter, my lord, maybe taken up after the orders, my lord. We'll see. 21. That's it. Much. But small prayer, my lord, item number 9, my lord. 9. 9, my lord. But the tender matter, my lord, they are going to open punishment today, my lord. At any time. But they are so, my lord, out to me, my lord, arbitrarily, my lord, so, my lord, I pray that this matter will be taken up part, my lord. They are going to open, my lord. You cannot do anything, sir. We'll see. Hello? We'll see. But if even my lord, we could file a Friday, my lord, if it is a, in fact, my lord, others who have, they, last meeting, my lord, they give me only 2 days time, my lord, for 1 month. You are supposed to, my lord, publicize the technical bit, my lord, they have kept it arbitrarily, my lord, and then only on, my lord, 28th, my lord. They uploaded it, and my lord, I got in 2 days, my lord. So it's Friday, my lord, Saturday, Sunday, holiday. You cannot do anything, it's 30 minutes. Up to your lordship, my lord. What can you do? We'll at best we'll be able to sign at 1 o'clock only. If any order is political, my lord. Political item is listed, my lord. No, I know this item 9. Even if we take up, if we pass order also, we'll sign the order at 1 o'clock only. No, my lord. In fact, my lord, that can be communicated, my lord. Normally, my lord, your lordship is aware that, my lord, if you can communicate. Normally, this court is averse to the still stays in the tender matter. They are supposed to, in fact, they're supposed to on 15/9, 15/10, the matter was evaluated. The issues were evaluated. They kept it for 1 month, 5 days. They kept it intentionally. And only uploaded only on 28th. Giving me 2 days time. From Guwahati, the petition was filed on Friday, we filed. So, the 20 was the financial bill. They want to open one, that was scheduled. September itself, that is fancy will be open on 26th month. So, my lord, they didn't inform, my lord, as per the tender, they have to 5 days, my lord, they have to upload it. As per tender, I will so lordship, my lord. But my lord, they kept it intentionally, my lord, so that out me, my lord, I will do it. So, my lord, I filed itself on Friday, my lord, but Monday being holiday. So, my lord, we have an option, but so, my lord, I only prayer that, my lord, if lordship will taken as part Friday, my lord, perhaps, my lord, our purpose will be start. Whatever the other. But I put 1 and 2, my lord, I made them, my lord, 1 and 2, 1, 2, my lord, I requested them. Okay. I do, my lord, if you okay. Okay. Yes. Obvious, my lord.
May I, your lordship? Lordship, I beg to mention item number 12, your lordship. Here we are going to, we have not filed our counter affidavit.
Well, which order we'll see.
Yes,
Just wait. Any other mention?
Lordship, I would like to mention item number 20, your lordship.
20.
Yes, your lordship. Here we have to file affidavit, your lordship. May I kindly take up this matter after 3 weeks?
What about what petition?
Yeah, I've taken the consent of the petitioner.
On the prayer of MS Arbasa, list this matter after 3 weeks so as to enable the state to file affidavit in opposition.
Lordship, I am appearing for power grid in this matter. Item 20. My presence be recorded on.
Yes. You are for?
Power grid, Lordship. Power grid corporation.
Mr. N. Kera.
Respondent
Stanley Counts for Power Grid.
Power grid, Lordship. Respondent number 2.
Respondent number
2, Lordship.
Respondent is present.
I'm bringing for taking up of unlisted matters.
What is the urgency?
My lord.
What is the urgency?
Urgency is, my lord, we have disqualified one of the candidates in Ansu election. And it was.
Tomorrow, we'll see. Tomorrow, we'll see. Tomorrow. All students' election. It's okay, tomorrow.
But election process is on, my lord. Election process.
We cannot interfere. Is there any civil suit?
Yes. Already interim granted.
Then?
Therefore, we are here for vacating the.
At 2. We'll see at 2.
Lordship, I have objection regarding this unlisted matter. Already the appeal is pending before CGM. Moreover, matter is listed today itself. In item number 44.
2 o'clock, it may not be maintainable. Are you appearing?
No, your lordship, just to inform this honorable court regarding the.
We'll see at 2.
Unlisted.
Yes. Please, Lord, see, I am obliged, my lord.
Yes, yes. Please go ahead.
But in fact, my lord, this is a tender matter, my lord. But in fact, my lordship will find the tender documents, my lord. Page 33, my lord.
Page 33.
Yes, my lord. In fact, my lord, the pursuant to my lord, the tender, my lord, the petitioner submitted the tender, my lord. For technical bit, fancy bit, my lord, technical bit, my lord. My lord, lordship, my lord, whatever the tender requirements were there, my lord, in conformity with that. And all the documents are submitted and everything are uploaded. Now what happened, my lord?
You are agreed by your rejection.
Yes, my lord.
Where is the rejection?
Yes,
Let
my
us
lordship
see.
will kindly come to page 135, my lord.
135.
Yes, my lord. They made evaluation and my lordship may kindly come to page 136, my lord.
36.
136, down below, my lordship, my lord, what the observation is, my lord. May I read, my lord?
Yes.
The board constituted for the opening of the online NIT height so and so, dated 19th September, that was the bid date, my lord. Opened and scrutinized the documents on 15th October at 11 hours in the office chamber of Chief Engineer, PHE, Namsai, and 5 firms, namely 1, 2, 3, 4, 5. My lord, we are concerned with, my lord. My lord, lordship may kindly come to next line.
You are one only.
One, my lord. We are concerned with one.
Have
only.
not been submitted the copy of certificate undertaking regarding
Yes, my lord.
form not being blacklisted.
Submitted the certificate, but what the ground, but they have stated that we have not submitted the copy of certificate undertaking. We have to give the undertaking, but what they say regarding the farm not being blacklisted by state, central government. Moreover, Mukund Poly Products, that is my lord, with listener, my lord, Guwahati, instead of they have submitted EMD, unexplained deposit, in the form of FD letter with deposit advice. Therefore, both the firms does not fulfill the terms of conditions of NIT indicated in the comparative statement. So, my lord, the only ground they stated that,
Yes.
my lord, we have not submitted the undertaking that we are not blacklisted. That is one. And number two, my lord, so for the FD is concerned, my lord, that we have not, we have given only letter of advice, my lord. So, my lord, in both the cases, my lord, before coming to that, my lord, I will first show the, my lord, the requirement of the tender, my lord. That is not the requirement in both the cases, my lord. That
Let
I
us
show-
see.
My lord.
What is the requirement of undertaking?
Yes, my lord, I will come to that, my lord. Lord, so may kindly come to. So for NIT is concerned, my lord, may kindly come to say, it starts from 26, page 26, my lord. My lord, may kindly come to 27, page 27 of the NIT, my
Supply
lord.
of ISI mark high density polythene.
So NIT, my lord. So, my lord, these are the eligibility criteria, my lord. On 27, page 27, 1, 2, 3, 4, may I read, my lord?
One?
My lord, so far page 27 is concerned, my lord.
Hmm.
These are eligibility criteria.
Yes.
May I read, my lord? Criteria number 1, my lord.
Hmm.
There, what happened, my lord? HDPE pipes manufacturer with valid authorization license as on date, opening date will be eligible for purchase. The tender are marked and closed copies of documents. But there, my lord, the documents of submission of documents were mandatory. Then Lordship may kindly come to 2. But we don't fall in that. But Lordship may kindly come to seal number 2. That, my lord, the manufacturer participating in the tender should have minimum 2 years of experience manufacturing, supplying of the government organization or department in hilly areas, India. From the tenderer should furnish performance certificate. There, my lord, the requirement of submission, again, my lord, incorporating clause 2. Then 3 also, my lord, the supporting documents are required. Clause 3. Then Lordship may kindly come to clause 4. There, my lord, no supporting documents is required. Then, my lord, 5, but we are 5. So far the 5 is concerned, my lord, that's the interesting. Here also not necessary. The manufacturer participating in the tender could not have been blacklisted in the past by the central oblique state government departments on the part of manufacturing and should not have pending supply of HDPE pipe for more than 2 years to the state government department. Here also, my lord, the requirement of submission of documents is not necessary, my lord. Then 6, my lord, again, the treasurer must furnish, they are the requirement. 7 also requirement, 8 also requirement. So, my lord, so 4 and 5, but submission of documents were not necessary, my lord. So, my lord, the ground that they have stated for, my lord, ousting me, that the, my lord, undertaking should have been given is not the requirement as per the NIT, my lord. It's not an NIT requirement. So, for the 1 is concerned. Then second 2 is concerned, my lord. Lord, may kindly come to say that the EMD, that is not in the form of letter, they say. So, first of all, I will take your lordship to page 133. That is in conformity again with the requirements of the NIT, my lord.
Page 35,
Page 133, my lord.
133.
Annex 4.
Four,
133, my lord.
133.
My lord. This is issued by HDFC Bank, my lord, whereupon FD was issued. My lord, may I read, my lord?
No, what is the requirement of,
But they said that only covering letter is given. So covering letter, forwarding letter is given, they said, but it's not fact. May I read, my lord? This covering letter is issued, is to be annexed to the fixed deposit number so and so dated 30th September for an amount of is so and so, so and so. Then lordship will can see, well, lord, the next para. This fixed deposit issued to our customer in favor of the department stated below. Chief Engineer PhD, Namsai. So, my lord, FD, what was the requirement under the NIT, my lord? It was also given, my lord. So, my lord, the ground, they said that only letter is given. It does not hold water, my lord. It's not fact.
no, what is the requirement of submitting this FD or
Yes, my lord. Yes, my lord.
demand draft for EMD?
Yes, my lord. Lordship may kindly come to page 42.
42,
Close bid security, close 17.
42.
My lord.
Yes.
May I read, my lord? The bidder shall furnish 17.1. The bidder shall furnish as part of bid as a bid security in the amount of rupees 88,565. 17.2. The earnest money deposit shall be at the bidder's option to be in the form of a demand draft or deposit, a cold or banker's check or fixed deposit sheet. We have given a fixed deposit sheet, my lord.
Yes.
So, my lord, both the
If I have spoken to the official, can it be taken after some time?
Why?
Because the requirement of this undertaking is given. Because I could not locate that.
No, sir, how the department will know that you are not blacklisted? You have to give something.
my lord, if whatever the mandated documents.
If it
are
is
there-
blacklisted, then only you'll, according to you, you'll have to furnish the undertaking.
No, my lord.
I mean, the certificate.
Because whatever the NIT.
You have to tell them that you have not blacklisted. That will be way of certificate or
No,
undertaking.
my lord, what they did, my lord. Now.
I think that is requirement. No, it's not necessarily to
Not
to
necessarily.
clearly submit the certificate. You'll have to tell them that your form has not been blacklisted. I think the requirement you have not followed.
My lord, now, my lord, what happened?
And so far as page 42 is concerned,
My lord,
for EMD, you have the option of in the form of demand draft or deposit at the call receipt or banker check or fixed deposit.
we have given fixed
This is a cover letter only. What is the
fixed
fixed?
deposit, my lord. So, my lord.
Is
what
it the certificate in 134? Can it be called fixed deposit?
My lord, fixed deposit, my lord, fixed deposit, my lord, fixed deposit is given.
Somebody is writing that it should be treated as a fixed deposit. Cannot be allowed.
My lord, fixed deposit is fixed deposit, my lord.
What is the requirement of
Fixed
fixed
deposit.
deposit?
Fixed deposit, my lord. Requirement, my lord, either fixed deposit or my lord, banker check.
In any case, I think prima facie clause 5 of eligibility you have not.
My lord, civil can
Forward.
see, non-civil can see what they did. My lord, see now, lord, see their conduct, my lord, not what they did. My lord, when 1510, my lord, they evaluated it. But as per requirement, my lord.
Sir, it's okay, we'll not go into that at this stage.
Also,
Whether you have been found to be prima facie rejected, I mean validly rejected or not, that's we'll have to see.
not fully rejected. my
So
lord.
prima facie, according to this code, you have not fulfilled this clause 5.
My lord, so kindly-
We'll accept that the clause 17,
my lord,
page 134, we may accept that it can be treated as a FD, fixed deposit.
FD, my lord.
But so far as whatever clause 5, if you are
No, not necessary, my lord, because it's submitted.
how they know that you have not been blacklisted?
My lord, requirement, so requirement, my lord, as per clause 5. Clause 5 says.
And
But Lordship can say,
it
again.
can have two interpretation.
No,
You
my-
may be correct, but
No.
if two views are possible, it's the decision of the authority,
My lord, Lordship kindly appreciate.
not by you and not by us, not by even by the court.
Lordship kindly appreciate, my lord. A tenderer, my lord, Lordship. A tenderer, my lord, as per requirement, will submit every document.
Yes, this manufacturer participating tenders should not have blacklisted. That's it. How they will know that whether you have not been blacklisted or you have been blacklisted?
But Lordship kindly appreciate one thing. my lord.
Why don't you give a certificate that I have not been, my firm has not, manufacturer has not been
And
blacklisted?
Lordship, then my lord, that case, my lord.
Otherwise, this will be redundant if you don't have to provide them any information.
In fact, my lord, Lordship, my lord,
Show us any information, even a letter or application that you have not been blacklisted.
my lord, in fact, Lordship kindly see, my lord. Since, my lord, since 1992 or 19, we have been supplying to same department, my lord.
It's okay. What's the guarantee? What is the guarantee if you are supplying for even for 15 years?
My lord, in fact, my lord, Lordship can only appreciate one thing. Lordship kindly come to my lord this page, my lord. Then Lordship will appreciate everything, my lord. In fact, my lord, if Lordship kindly come to 138 page, 138.
Sir, let us not make it complicated.
But not-
At this stage, we'll go by on what ground you have been rejected. One is non-submission of certificate or undertaking that you have not been blacklisted. Number two, they have not considered that the covering letter as a fixed deposit. Number one, this court prima facie that you have failed to submit that.
In fact, my
I will at least inform them that you have not been, the firm has not been
lord, in that-
blacklisted.
But if Lordship-
But other one, I may agree that it can be considered a fixed deposit. But if only one ground also can be made you ineligible.
No doubt, my lord, no doubt. But in my lord, Lordship is.
So and at the best, sir, this will have a two-way interpretation.
My lord, Lordship kindly, my lord.
Maybe you may be correct or they may be correct. We'll
No,
examine it.
I
We'll issue notice.
My lord, I fully agree with you, Lordship, my lord, not only my lord, now this thing.
Yes,
In fact, my lord, they gave me.
we'll make it subject to outcome.
My lord, in this case, my lord, they did state, my lord, because my lord, nothing.
No, we cannot. We cannot. We'll just.
Second is going to fall, but for my lord, when they waited for 1 month, 5 days, my lord. For my lord, but when it was fixed.
No, prima facie, sir. Prima facie, I find that this court finds that this clause 5 has not been complied with.
My lordship will kindly, lordship, this issue, my lordship may.
And it's a matter of interpretation.
But lordship may kindly.
It doesn't give in the clear, I mean, language that you should participate, submit the certificate or undertaking.
No, no, no.
It doesn't.
Very.
It doesn't say so. That's what I'm saying.
No, very.
So the interpretation of the authority is the final.
No, it has to be, my lord, in conformity with the NIT, my lord.
Yes.
Interpretation, my lord, of
Yes.
authority, my lord, that can be in deviation to the requirement.
So what's the use of having this clause? Conditions?
My lord, may I?
Close
My
file.
lordship, my lordship,
Yes.
kindly appreciate, my lord. Lordship may grant you only 2 months time. My lord, if they
No, I
have,
have appreciated, sir.
my lord, in fact, my lord, they have the authority, no doubt.
I have appreciated and
They're not, my lord.
you may be correct. But the view, if there's a two possible views, view of the authority has to be
In that case, my lord.
given
Judicial scrutiny is the
difference.
only option, my lord. Now, my lord, lordship will kindly.
We'll see, we'll examine,
My lordship will kindly.
we'll make it subject to outcome.
My lordship will kindly do one thing. My lordship kindly. A short date may be given, my lord, and date may need to be stated because my lord, they should not proceed, my lord, with the opening of the.
No, we
Finance
cannot.
Summit, my lord.
We
Finance
cannot.
Summit today, they fixed, my lord, when this 19th September was the date for, my lord, for choosing today, my lord.
We'll finally decide, let them come up with that.
But in that case, my lord, my intention will be virtuous.
See,
My
then
only.
we'll see subject to the outcome, then let them take the risk.
Every statement subject to the outcome, my lord. Every state.
No, we'll not stay, we'll say the tender, any process shall be subject to the final outcome of the petition.
Oh, my
That's
lord.
why.
My case, my lord.
Why not stay at such?
Oh, my lord, I will not be off. My lord, I will.
No, that we cannot.
Huh?
We'll just say that that will be subject to outcome. That's all. Nothing else.
subject to outcome, I am obliged, my lord. Subject to outcome of this petition, my lord, they will not proceed with the finalization.
No, that will be indirectly amounting to stay the
My lord, only.
proceedings.
My
We'll say award or the process of tender shall be subject to the outcome of this. Final.
my lord, I-
We'll say the finalization or the award of tender shall be subject to outcome of this panel writ petition, outcome of this writ petition.
But they will not process, my lord. Now,
No, that we cannot. They'll proceed.
Only, my lord, Lord, Deep, Lord, my lord, I'm put next to my lord, I am obliged, my lord. That lord, so that's, my lord.
See, sir, it's not that we don't want to, I mean, basically, we should not stall the process, but then at the same time, you have to establish privacy. Privacy, I find that this is clause 5 is.
They may be informed, but the council may inform the party that they will not would settle with anyone.
No, that we can.
But otherwise, I would have been subject to government only.
Once this court decides, suppose if your writ petition is allowed, things will be, clock will be turned back, that's all.
I'm obliged, my lord, not only lord, simply access to one aspect of the matter, my lord. But as per the requirement of the NIT, my lord, within 5 days, they were supposed to open, scrutinize the technical bit and upload it. But they have waited for 1 month.
Suppose if it was open, how this requirement of clause 5 and 34 would have changed?
That judiciary is to scrutinize, my lord, will scrutinize, my lord.
That will scrutinize.
Or we fail, my lord. So, my lord,
At this stage.
till then, my lord, till then, my lord, my lord, so 1 month, 5 days, my lord, so they waited. They can wait for another 6 days or 10 days, my lord.
That
So,
we-
my lord, they can do one thing, my lord. They can do one thing, but they can do one.
Sir,
But it's,
you-
my lord, for matter of equity, my lord.
Sir, you know better than us.
No, my lord, you lordship, my lord, but I'm my lordship, my lord, whatever lordship, my lord, I'm learner, my lord. Lordship knows better than.
No.
My lord, my only thing is that, my lord. My lord, only.
We learn from you, we're learning from you.
My lord, my lord, only lordship will kindly see one thing.
Well, and we'll keep learning.
My lord, lordship will kindly only see one thing, my lord. My lord, nothing will, my lord, nothing will happen, my lord. See, they can say that. Let them wait, my lord.
Yes, why what time?
Today at 11 AM, they said that they can inform of our.
Whether this particular lawsuit condition undertaking is a mandatory or not. That part lawsuit I have spoken, they are just sending me.
If it is not mandatory, will it stay?
No, it seems it's mandatory. They said it's mandatory. Then how it's mandatory? They
No, what they are saying is their submission of certificate or undertaking is not required even as per this clause. Suppose if the manufacturer is not blacklisted, what's the question of submitting? According to him, it has not been blacklisted. So there's no requirement of saying that the manufacturer has been blacklisted. It says participating in a tender should not have been blacklisted.
Yes, my
This
lord.
is what he's saying.
no.
What's the question of mandatory, not mandatory?
Lawsuit is this condition law. Whether lawsuit.
This condition, according to privacy view of this court, has got 2 interpretations.
Oh.
He may be correct, but the court is in view of the settled position of law, is of the view that if it is the interpretation of the authority that the undertaking is required, if there is 2 possible views, they are correct. That is by privacy view.
Lawsuit.
That's all.
Authority said lawsuit. This is a mandatory lawsuit. Because sometimes lawsuit.
No, it's not question of mandatory, not mandatory. It's interpretation only.
Law.
It clearly, when you read the language, doesn't require any certificate or undertaking. What it provides, it should not have been blacklisted in the first by any central or state on so and so. That's all.
Lawsuit.
But you have rejected his tender that you have not submitted either undertaking or the certificate that you have not been blacklisted.
What I thought is lawsuit, other than this lawsuit, any other lawsuit clauses is their lawsuit. Where lawsuit is given lawsuit, this undertaking has to be deposited, submitted lawsuit.
Where it is?
No, just I have thought that information from the.
No, what information? They cannot, I mean, manufacture now the requirement of the clauses.
No,
You have to show from here only.
correct lawsuit. And other than this particular lawsuit, the entire EM SBD lawsuit is in the bidding documents lawsuit. Just I told them to locate lawsuit.
Where is the SBT?
SBD lawsuit, it seems lawsuit, whether the pool lawsuit
Everything is here.
And apart from so called lawsuit, FD is concerned lawsuit. What authority says lawsuit? The format of the EMD lawsuit, the
Hmm.
fixed deposit. That cannot be substituted by the lawsuit, the cover letter.
That I understood. What is is there any format?
EMD has its own format lawsuit. The fixed deposit.
Okay.
Fixed deposit lawsuit as such, it has its own format.
Well, issuing notice, sir, will say subject to outcome.
My lord, only my lord, is let it pair, my lord. It will pair, my lord. Let the honor the court.
We'll fix, we'll fix, sort that will fix, but whereas, we'll just say the subject to outcome.
Any sort that, my lord, if the my lord, if the my lord, I don't fulfill requirement, my lord, if there's a requirement was there and I failed to comply with the requirement, my lord, I have no case. Well, definitely I have no case. I will not argue much. But now the question is that, my lord, they have to justify the honorable court, my lord, whether the as per NIT these requirements were necessary or not. If not necessary, my lord, they can offend, my lord, in the relationship, something they cannot incorporate, that these are the requirements, my lord. It cannot be by bypassing the NIT requirements, my lord. So, my lord, here is the case, my lord, they incorporate something, my lord, which the NIT does not require, my lord. So, my lord, in that case, my lord, I have a primary case, my lord, that I pray before the court, my lord. Let the case may be judicially scrutinized, my lord. Any sort that may be fixed, or let Lord Courts, Lord, she will kind of see if this. my lord,
Sorry,
finds-
sorry, sir, I'm not convinced.
My lord,
Will,
but the
but then will returnable then will fix it within 2 weeks and we'll say subject to outcome. That's all. Subject to outcome, that's all.
yes, my till that they will not
No,
do anything. my lord.
No. Hot Mr.
Todi, my lord, BP Todi, my lord.
BP Todi, learned senior counsel, assisted by MS
Das.
Spencer, learned counsel for the petitioner. By filing this writ petition, the petitioner has put to challenge the rejection of this technical bid,
Technically.
rejection of the technical bid. Dated 15/10/2024. Pursuant to the, where is the NIT?
NIT, my lord, Lord, she may kindly come to.
NIT.
NIT, my lord, Lord, she will find it page 26, my lord. At page 26.
NIT dated 19/09/2024. Issued by the Chief Engineer within bracket Eastern Zone E/Z bracket close PHE and Water Supply Department for supply of ISI mark high density polyethylene pipes suitable for water supply. Page 26, huh? You just read that. Mr. Todi, learned senior counsel, referring to the rejection, a technical bid evaluation, a comparative statement for technical bids evaluation, submits that the case of the petitioner has been rejected on two non-existent conditions of the NIT, namely requirement of submission of certificate of undertaking regarding the farm not being blacklisted by state or central government, and non-submission of demand draft fixed deposit for EMD. He submits that as per clause 5 of eligibility criteria, it only requires that the manufacturer participating in the tender should not have been blacklisted in the past. And there is no requirement of submission of any certificate or undertaking to that effect.
Well,
Since the petitioner has not been blacklisted in the past, there is no requirement of submitting any certificate or undertaking. He further submits that so far as further submits that regarding the non-submission of demand draft oblique FD for EMD, while referring to, where is that, 134?
my lord, 133, my lord.
130. He further submits the
FD given, the covering letter also given.
fixed deposit. Although in a fixed, the covering letter clearly indicates the fixed deposits which is required to be accepted by the respondent authorities. Therefore, he submits that pending final determination of the present proceedings, an interim order is called for. As prima facie, the rejection of the petitioner is on non-existent conditions of the NIT. Issue notice returnable by 2 weeks. Mr. S. Tafin Laden, Senior Government Advocate, enters appearance on behalf of the state and accepted notice for all the respondents.
Hold on.
Mr. No formal notice need be served. Issued non-formal notice need be served. However, extra copies will be furnished to the land. Next paragraph. Heard on interim prayer. It is noticed that as per clause 5 of NIT dated 1909. Is it 1909, sir?
My lord.
1909-2024.
Yes, my lord.
It provides provides as one of the criterion that the manufacturer participating in the tender should not have been blacklisted in the past by any central or state government department on the part of manufacturing, and should not have any pending supplying of SDP pipes for more than 2 years with the state government department. As per clause 17, where it is, that page 42.
My lord. Wait, my lord.
Hmm.
Clause 17, my lord, page 42, my lord.
Clause 17.17.
17.2.
17.2. The earnest money deposits shall at the bidder's option be in the form of a demand draft or deposit at call, receipt or banker's check or fixed deposit receipt. On consideration of the above conditions and the eligibility criteria, this court is of the prime view that as clause 5 requires that the manufacturer participating in a tender should not have been blacklisted, it is the duty of the petitioner to inform either by a certificate or undertaking that the manufacturer who has participated in the tender has not been blacklisted in the past. Prime facie, this is my prime facie. At the same time, on cursory reading of the said eligibility criteria, even if it if it may entail any two possible view of interpretation, comma, deference should be given to the interpretation given by the authority. So far as the submission of cover letter as an MD, submission showing fixed deposit for EMD, comma, unless a specific form is given, it may be treated as a fixed deposit as the same has been issued by the concerned or concerned established bank, i.e. SDFC. Next, having considered above, this court is of the view that no interim order is called for, staying the process of the tender in question. This, however, same shall be subject to the outcome of the present writ petition, list after 2 weeks. In the meantime, the state may file their affidavit and please produce the records.
And this whole month, this is not supply, it's for empanelment, madam. The tender is for empanelment of.
It's okay. No, we're not saying anything.
Madam, so madam, in fact, madam.
We're not installing the process, tender process, but we're saying that it shall be subject to the outcome.
You have to submit, madam. But in fact, madam, it was not mandated, that's why other, madam, everything could have been submitted, madam.
We'll see, we'll see.
Madam, 10 items. were-
We'll see, we'll decide after 2 weeks.
Lordship, I'm sorry, Lordship, because regarding this blessing, the page containing this particular clause pilot is missing from my petition.
Okay,
So therefore, I was getting confused.
it's okay. You just give,
Otherwise,
Madam, maybe, madam.
it's not here in my page.
kindly ask your junior to supply the.
So thereby I have spoken to the authority, where it's given, it's
Okay.
missing from my
I'm
petition,
sorry,
so I
madam. In
was
fact, madam,
completely
but
confused.
so hurriedly, madam, in fact, madam, 20th, madam, is uploaded. 21st, only one day, madam, it was prepared in Guwahati, madam, and on the Friday, madam, it was filed in Itanagar, madam. Saturday holiday, fourth Saturday, Sunday holiday, Monday holiday, madam. And 2 days, madam, we had. And for 1 month, 5 days, madam, they didn't upload, madam. Madam, what is mandated is as per the NIT, madam, within five working days, madam, it has to upload.
We'll consider that also. You have taken that plea also.
Madam, we have taken that, madam.
Otherwise, clause 15, it makes it very clear, Lordship, that undertaking has to be given.
It's okay, madam,
It
but,
was 15.
Clause 15.
but
15 or 5?
No, clause 15.
if that is there, madam, we will have no case.
It's not undertaking, it says, kindly see it, Lordship. Disqualification to perform the contract law. Page 41. Lordship. Page 41.
Yes.
B, I'll read the B, Lordship. All information to prove qualifications and eligibility of the bidder as necessitated in the bid, Lordship.
Yes, necessary in the bid. So if necessary, it's not necessary.
This is bid, Lordship.
Like necessary in the
Bid,
bid.
Lordship.
True, madam.
We should not also pass any order that's subject to also.
No,
It's
no.
always there.
Always there, Lordship. This always there, Lordship.
Sorry for your efforts.
Madam,
Anyway,
I'm obliged, madam. Deeply obliged, madam.
yes,
Item number 1, 2,
This
3,
order
and
for-
4.
14/05/2024 was under what provision?
My lord, under section 29(4).
4.
29(a)(4).
A4. Then why second
My
extent?
lord, the evidence says, Lord should see at page 31. Sorry, my lord, that page 28. The
28.
evidence says could completed, my lord, because of the voluminous nature of the
Let
matter.
us read 21, 28, 29A4.
29(a)(4), my lord, is.
This is the application under 29A5 or A4?
A14.
29A4 or 29A5?
29(a)(4). 4 is the enabling provision, my lord. When the.
Then your
subsequent provisions-
application has to be under 29A5, is it not?
Five only says, my lord, that.
Application has to be filed.
Sufficient cause is shown, my lord, then five is. applicable.
Arbitration, conciliation. Any objection, sir? Well, dispose it of allow another 6 months.
A4, my lord, as I understand, A4 is the enabling.
Just
provision.
wait. If
Given
there,
jurisdiction to the court, then the clause 5 is, my lord, the provision that's saying that you extend it only when sufficient cause is.
Hmm?
So 5 is basically recording of reasons as to why extension is to be given.
Yes.
So an extension period as referred to in subsection 4 on an application of the parties may be granted only for.
No,
sufficient-
that has already been granted to another 6 months.
Yes, ma'am. Do you want further extension?
To under further extension under what provision? That is why I'm asking.
My lord, the 4, my lord, does not specify that it can be extended only for a particular period of time. 6 months at that point of time was deemed to be probably the amount that time that would be consumed. Because 4
If
does
the
not
award
say
is
as
not
to.
made within the period of specified, so there was an extended period of prescription, so the mandate of arbitration, unless the court has either prior or after the expiration, so it's the extended period. The court has already extended another 6 months.
My lord.
Then the extension of period referred to in subsection 4 may be on the application of any of the parties and may be granted only for the subsequent period, which terms and conditions may be proposed by the court.
My lord. So 5 is basically when sufficient reasons is shown, then you exercise the power under 4.
No, sir, once this court has extended
My
another
lord.
6 months. All right,
My
I understand 12 months plus 6 months, 18 months.
That is the.
There,
only-
even after that, if there is sufficient reason, can be extended.
My lord.
But as a form,
As a form.
since you have filed an application under 29A4,
A4.
why this is section 5?
Section 5, the reasons as required under subsection 5, we have shown in the petition. My lord. As to what had happened during this
No, that's
extended
what I'm
period.
saying. As a form, it has to be filed under section 29A5 or A4.
A4, my lord.
A4, under A4, it can be extended.
Extended.
But A5 is a form where you have to file an application.
A5 is. the
Let us read,
reasons, my lord,
let us read this.
My lord.
The extension period referred to in subsection 4
4.
may be on the application of any of the parties and may be granted only for sufficient cause.
My lord. The application refers to.
No,
I understand
the extension,
application under
no,
4.
extension will be under section, subsection 4. And for that, you have to file the application under subsection 5.
My lord, my
And it can be
understanding.
extended
My
on
understanding was that.
sufficient reason.
My lord, my
Sufficient
understanding was
cause.
that. My understanding was that you file under 4 and then show causes under 5. When I file an application under 4 and I show causes that are sufficient causes under 5, then the powers under section 4 is.
I think we can extend another 6 months.
Malad, here our instruction is I have got to respondent number 2 and 3, Malad.
Yes.
There is a Malad, small objection from the Malad, the respondent number 2 and 3, Malad.
Where is the objection?
Malad, objection regarding Malad, the cedula fees, Malad. Cedula fees has been prescribed, that Malad, the cedula fees, Malad, put forward by the Malad, the arbitrators, it goes Malad beyond the Malad dealing limits. Schedule 4. So therefore, Malad, just to that extent, Malad, we wanted to file objection affidavit. Within
No,
a week.
that would be a different cause of action. It is only for extension of time. That may be a different cause of action.
Extension can be only granted when
See, if there is a, negligence or, if you find fault on the arbitrator, there's a provision that their fees can be reduced. But that will have to hear the arbitrator also. That is another issue. At best, a cost and the necessary appropriate order can be passed, including the reduction of the fees. But so far as the exceeding and all those things, as per the schedule, that is a different cause of action that you can sort it out.
another
In a different
extension,
proceedings or in the same proceedings, in the arbitration proceedings also. So there should not be any ground to, not extending them if they can show the sufficient cause. I think prime facie sufficient cause is there. despite after, because of the voluminous thing, they could not complete the process. So we'll extend when disposing it.
Only to the, they will, that may be granted so that we can come with the instruction issue from the mother. We
We'll
wanted
dispose it
to,
of what's there.
we wanted to file the affidavit, man.
Who are you?
For the respondent, Malad, basically more
The
Ministry,
Ministry
my
of Road Transport and Highways, my lord.
respondent number two.
Because
is-
as I understand, my lord, your lordship would see that in my page 31 onwards, there
Every
is a
time
order.
my lords will be
That
subject
the schedule of fees was objected to before the tribunal because of the length of time consumed. The fees which was to be paid per day has gone beyond the fourth schedule as of now. Ministry is of the view that we cannot, in view of the AFCON's decision, we will not be paying fees beyond the fourth schedule. That is one of the contention of the ministry. That order of the tribunal has already dealt with. And the tribunal has recorded that you provisionally deposit only the amount that is deemed according to you payable under the fourth schedule. So that has been dealt with by the order, but then the ministry probably, my lord, as my understanding goes, they want to simply bring it on record so that in a subsequent stage, my lord, they can come up with this ground of, my lord, the payment of fees if so required in a subsequent stage in, when the matter goes in appeal or in some other proceedings, my lord. Because as far as objection of fees is concerned, under section 38 also, this can be raised. The subsequent stage when the award is delivered and fees are not settled, then applications under section 38 has to be filed, my lord. Let them bring on record, my lord, because otherwise we also don't want to engage in too much of technicality. Let them bring on record, my lord, their affidavit, whatever they want to say.
A week time will come with it.
It's up to you in that case. Have you, what about this judgment after the judgment of 12-9 in Rohan Builders case?
Rohan Builders, my lord, has said that the application can be now filed at any time, even after the mandate has expired. It can still be filed and still be refined, my lord. Rohan versus
Berger Paints.
my lord. So it has basically widened the scope of section 29 by saying that at any stage the proceedings just because of lapse of time should not get frustrated, my lord. That seems to be the purpose of this as well. So even if the mandate has expired, even after if the application is filed subsequent to that, my lord, the court can exercise its jurisdiction. So that is basically enabling the continuation of the arbitration proceedings.
So you want notice to be issued?
My lord, since we don't want, my lord, that ministry should come and again object to the extension also given. So if they have anything to bring on record.
Are
my
you
lord,
saying
let
that
them
there
bring.
cannot be any further extension?
Well,
Why?
extension can be malad only basically possible when agreed to the fees malad prescribed by the civil well. That is the malad whole contention.
No.
In fact, that has already been raised.
Read 29, 4 and 5.
Under that. That
Read
is
25,
one
5,
aspect, malad.
10.
That is one aspect, malad. Then how the fees will be generated is the one malad the aspect beyond the malad prescribed malad ceiling
No,
limits.
fees can be reduced in the event there is a failure on the part of the arbitrator.
Yes.
Appropriate order can be passed for reduction of fees also.
Yes.
Malad, in
But
fact,
if it is exceeds because of, you will have to establish, while extending this has to be, fees has to be reduced. In that case, again, we'll have to hear the arbitrator.
Yes. And on other aspects as to what would be the fees actually payable, if that dispute remains in the stage of award, section 39, my lord, there is a provision. That after the award, the parties can still contest the fees payable. Then.
Section 39.
Section 39. So that aspect, my lord, the ministry can explore in section 39. the aspect of total fees payable under the court schedule or whether it is payable or not, is not a subject matter of section 29 at all. It can at best be a subject matter of section 39. And anyway, since they want to bring that on record, my lord, let them have the opportunity of filing better reply.
Tomorrow they will come and say, no, that no opportunity has been given.
My lord.
It's okay. Or Mr. B. Pathak, counsel for the petitioner. It's the same, out of same contract.
The
Packages are different.
packages are different.
A, B, C, D. Same order, but separate.
The cause title has the contract name. Or lordship can say in arbitration case number 1, 2,
this-
3 and 4.
This is an application under section 29, capital A, bracket close 4, bracket 4, bracket close. Read with section, read with subsection, read with section 29A within bracket 5. 29A, huh? 4 and 5. Read with 5 bracket close of the Arbitration and Conciliation Act 1996. Praying for extension of mandate of the appointed arbitral tribunal comprising of Justice B.N. Kare from a Chief Justice of India, Justice B.K. Sharma from a Justice Guwahati, and Sri Sambhu Singh, age 1 and 2, huh? Former AS and FA MORT in respect of arbitration case number. First one is arbitration case number 4. 4, huh? You just find out. 1, 2, 3, 4.
Case number 1, 2, 3, 4, 1 and petitions are
Yes,
not numbers.
this one is 4 arbitration case. Filed by the
Petition not only case number 1, 2, 3. Yeah, the serial number
petitioner. It is noticed that this present application is filed for second extension as by order dated 14/05/2024. This court has extended the time for another 6 months with effect from 6 months from 23/05/2024 to 23/11/2024. Issue notice returnable by 2 weeks. 2 weeks.
10 days maybe. So we can finish.
10 days. 2 weeks or 10 days?
10 days will.
10 days.
Can I have it on 9th of December? Because it will be convenient.
10 days. Returnable by 9. In that case, 9. 10.
10.
10, 11,
Because
20.
they have to be available.
10, 11, 20, 24. 12, 10, 12, 20, 24. Mr. R.C.K. Lalu, Standing Counsel for Highway, PWD, Government of Arunachal Pradesh,
1 and 4.
enters appearance and accepted notice on behalf of respondent 1 and 4, and Mr. M. Kato, learned DSG, for respondent number 2 and 3. Next paragraph. Learned counsel for the learned counsel for the respondent number 2 and 4, 2 and 3 may file his response if so advised on or before the next date of listing. 1 to 4. 1 to 4, huh? You just check out. arbitration number will be different. Yes, any instruction?
Yes. Here lawsuit, basically when EMD is submitted lawsuit, bid, that the body should contain lawsuit, the address of the lawsuit, the authority, inviting authority, and on the top lawsuit, whether what document it is lawsuit, that has to be mentioned. And when it was submitted, it was blank, nothing was written there lawsuit. Then opponent lawsuit, other party, they objected, because though the bidder said this is EMD, but since nothing is written on the cover, so they objected, then it was not open. In the meantime, what happened? He himself, he took away and he left. And now after 2-3 days also, he came back and he asked for his EMD back. And he was already taken back his EMD. After that lawsuit, he filed this petition.
Withdraw dismissing with cost.
Lordship, no such instruction was received from my client.
ये आपका ही होगा.
Are you withdrawing or you will dismiss on merit and impose cost?
Even the executive put his signature on the, he marked to release the EMD to the bank.
Your executive engineer is very poor or what? What is the instruction? Any written instruction?
Written instruction is sent.
This is his letter only.
This is letter by the petitioner.
Because refund of EMD.
EMD.
Kamintaga.
If the original
Time tell. This is who is time tell?
of two petitioner. There are two
Next
petitions.
next petition.
Next petition.
Yes, sir. We are imposing a cost.
In that case, I am
You have
allowed,
declared the court.
allowed to withdraw. My lord.
Be careful in future. All right.
Deeply approved.
So we'll not record anything.
No, sir.
Or should we record and impose the cost
Actually,
on your client?
actually, no such instruction was received.
It should be very careful.
Yes.
It's your duty to extract the facts first, then apply the law. It's not just that somebody come and ask you to request you to file an application, you file a writ petition. Don't do that. It's for your future, career, I'm saying. All right.
Deeply obliged.
Heard Mr.
B Kamda.
Learned counsel for the petitioner. Not heard. Mr. B. Kamda, learned counsel for the petitioner. Submits that he may be allowed to withdraw this writ petition. Mr. S. Tapin, learned counsel for the petitioner. Learned senior government advocate is present. Next comment. The writ petition is still dismissed on withdrawal. Both the cases. Five and six, same.
Same.
Yes, return the. Will issue notice? What is to be?
I'm for, Mr. Jayashree is the special PP for SIT.
My lord, that I will file an IA for striking off, just
Okay.
not the necessary party,
Okay.
it came by mistake.
So he's
I'm presenting 1, 2, and 3 months.
not Mr. Deepak learned counsel for the petitioner. By filing this writ petition, petitioner has read for a direction to the respondent authorities, particularly the superintending engineer, coordination, department power, within bracket E, bracket close. Naharlagan. For declaration of the result of the petitioner in terms of the selection process initiated by the advertisement dated 12/6/2020 in terms of the office memorandum, various office memorandums issued by the government of India and the government of India and the Government of Arunachal Pradesh. Should I record the facts or not? It's not necessary.
Notice
Issue
that
notice. Issue notice
3 weeks.
returnable by 3 weeks. Mr. L. Permit, Learned Standing Counsel for Power Department,
My lord.
appears on behalf of respondent number 2,
1, 2, and 3, my lord.
1, 2, and 3. You strike off
I
unnecessary.
will
Not
try.
necessary.
Came by mistake.
Therefore, no formal notice need be served. However, except copies be furnished to the Learned Standing Counsel for the Power Department. List after 3 weeks. Sir, there is no improvement in your petition. Why you have withdrawn and why you have filed again?
Lordship, maybe allow for
I'm-
amendment, Lordship.
I am not able to understand in your synopsis. You have murdered the synopsis.
Lordship.
What's the use of having a synopsis if you cannot have if you cannot understand from synopsis? It's a short summary of your entire case. I am not able to get it. What do you say?
Lordship,
Your synopsis. You read and tell us.
that this institution has filed challenging the illegal obtaining tender technical constructions of the roads from NEC Road to Lanka package number AR 20 AR 030405 and 1 and the Bug Reader Bridge over the Lanka River has part of tender reference number AR 2004051B. Reference notice inviting tender number so and so and dated so and so. The technical bids opening was and conducted on the September 25, 2024 at the conference hall of the Chief Engineer RWD Tanagar in presence of the bidder and board members that the notice inviting tender for.
So your bid has been rejected.
Yes, Lordship.
On what ground?
And on the ground of that, Lordship, they're not submitting the documents, Lordship.
As per the terms and condition of the tender.
Yes, Lordship.
What is those documents?
The documents is, Lordship.
Tell us what's there. At least 1, 2 documents.
Yes, Lordship. Documents is there, Lordship. Clause 4.B and B1 and 2. And
Clause 4 point.
B, page
Yep.
number 18, Lordship, in NIT, Lordship.
18.
Yes, Lordship. And serial number, second, Lordship. From the part of non-selective, Lordship.
So when it is your name is
Yeah, it's.
serial number 1.
Yes, Lordship.
Clause 4.4. Then come to your prayer.
My prayer.
Page 12.
My prayer is that, Lordship, this.
You read the prayer first, then explain.
Prayer, Lordship.
Please read your prayer and explain.
In the premises aforesaid, it is therefore the most respectfully prayer that the honorable court may be pleased to admit this application and notice issue opposite party hear the party. A writ in the nature of the mandama could be issued to abstain from illegal obtaining tender by.
Yes, you explain this. What do you mean by this?
That is a illegal obtain, Lordship.
How we can issue a mandamus to abstain from illegal obtaining tender technical bid construction of road? What do you mean by this?
That I mean, Lordship, that to issue for the stop bidders construction, Lordship.
Your understanding has to be translated into written in the prayer. No, you should not keep within yourself. So what prayer, what relief can this court be given to you?
My prayer, Lordship, that maybe interim may be granted for the stop the next technical.
First, you let us know your main prayer.
Yes, Lordship.
What is your main prayer?
Main prayer, that's it, Lordship. My main
You have
prayer-
read it, explain it.
Yes, Lordship. My main prayer is, Lordship.
You
that
explain
maybe-
the meaning of this, not which has been kept within yourself.
That is, Lordship, they are illegal obtaining the tender, Lordship.
What do you mean by that? Abstain from illegal obtaining. I suppose it's an English language, but it's some meaning has to be there in consonance of your prayer. What is to be done?
Lordship may be hard.
Why issuing notice?
Yes,
You file appropriate, amended petition. At least your prayer should be amended. You want to be, your bid has to be considered, and you want to do the work. Okay, heard, Mr.
HT Tara, Lordship.
ST Tara. Well, write your full name, Pura. What is your full name?
Honi Tana Tara, Lordship.
Heard, Mr. Honi Tana Tara, Learned Counsel for the petitioner. By filing this, where is your rejection? Writ petition.
Earlier, Lordship, it was mistake, Lordship.
No, where, by which order, the order your bid has been rejected or evaluation?
It was rejected.
Evaluation.
It was rejected on ground, Lordship.
Page 18.
Yes, Lordship.
Page 18.
Yes, Lordship.
Yes. By filing this writ petition, petitioner has challenged the rejection of the bid of the rejection of the bid. What is the date? Page 18, any date?
Date is Lordship, there, Lordship.
Wait.
7/10/2024, 7/10.
7/10/2020. Where do we get it? Where it is?
Uploaded. Page 19 in my,
19.
yes. Technical bid document.
Okay. 19 is something 25/9.
25/9, that is date of uploading, download. Then it was, result was uploaded on 7/10/2020, down, signature document. That is digital signature, basically. Down there, right side. Bottom. This is
10/7. 10/7/2024.
But it should be 7/10. 7 October.
Okay, 7/10/2024. As being non-responsive as per, in terms of the clauses 4.4 point capital B, bracket small b, bracket close, bracket Roman, small Roman, bracket close of appendix to ITB, comma. No, not comma. And close 4.4 capital A, bracket small b, bracket close, bracket Roman 2, Roman is small Roman 2, bracket close of ITB. Page 18, serial number 1. Pursuant to the NIT dated 25. NIT dated 12/9/2024. issued by the Executive Engineer, public PIU, comma, RWD Division, Qualification, for construction of capital, BUG, GIRDER bridge over Lanka River, within bracket, span dash 60.80, bracket close, package number AR 2 AR 0304040551B at the estimated cost of rupees 568.48 lakhs. Page 19, description. Issue notice returnable by 4 weeks.
1 week already above it.
Mr. G. Tarak Lalit, Standing Counsel for Rural Works Department, enters appearance on behalf of
127.
227.
227.
Who is for? Then in that case, was Mr. N. Ratan Lalit, Additional Advocate General for Respondent number 1, and Mr. Swain. No formal mention of the extra spoken of funds to and the council for the response. Within 2
Amendment may
days.
be allowed. Lord.
Within 2 days.
Amendment may be allowed.
You file an application, it's not required. Anything else? Anything else? You want anything more? Issue notice, what is this? You don't want your allotment or you don't want your land.
I want my land, my lord. If my lord see the casual map, my lord. My lane is
Where is the order?
plot number 6, my lord.
Where is the order, impugn order?
24, my lord.
24.
Yes, ma'am.
You are basically agreed by direction to approach the civil court.
Exactly, my lord.
Yeah. What does it say?
My lord may come to page 27, my lord. Down below. After return,
By the enforcement.
all laboratory issues clearly we have without.
He has raised a very interesting question. It's a remedy proceedings. Civil courts are barred
My lord.
under the act. It's an interesting question. I mean, the law, legal issue.
Section 95 of the.
Will issue
Act,
notice.
2002 Act.
You cannot mix the things. No, revenue proceedings, civil cases are quite different. I've come across in my 25 years of
But then, my lord,
practice.
in my humble understanding,
It
my lord,
appears to be very small, but it is very interesting.
my lord. Because,
You'll have to settle the law.
because the,
Heard Mr. Opada, London Council for the petitioner. Challenge made in this application is to the order dated 28/08/2024, passed by the Deputy Commissioner, Upper Subansiri District, Arunachal, Upper Subansiri District, Dapurija, whereby the Land Deputy Commissioner has held that the Deputy Commissioner is no longer having a jurisdiction to try a civil suit in view of the enactment of Arunachal Pradesh Civil Courts Act 2021. Next para. Next, thereby directing the parties to approach the appropriate civil court for redressal of their grievances. Next para. Mr. Opada. learned counsel to the petitioner submits that the issue arises out of land allotment of government land
my lord.
to the parties, where the revenue proceedings has to be which has to be determined in accordance with the revenue proceedings, in accordance with the Land Settlement Act. What is that? Arunachal Pradesh Land Settlement Act
Land Recording
2002.
Settlement Act, 2002,
2002 or 2000?
2000.
2000. Somewhere you have said 2002.
I think there is a
Find out.
typographical mistake. now.
2000, right?
2000.
Land settlement. You just read, give the full.
Arunachal
Arunachal
Pradesh,
Pradesh
in bracket, Land Settlement and Records Act 2000.
Land Settlement and Records within bracket
Yes.
Act 2000 by by way of revenue proceedings. Mr. Therefore, the impugned order is contrary to the law. Mr. Issue notice returnable by 4 weeks. MSG at the learned additional senior government book enters appearance on behalf of respondent. Respondent number? Respondent number 1, 2, and 3.
3,
1, 2, and 3. 1 and 2 and 3. None appears for the respondent number 1. Have you served the notice?
yes, ma'am. I will
Despite
report that Mr. Khandu is
service
out of
of
station.
copy, despite furnishing of copy to the understanding council. List of next paragraph. Now, since Mr. G at the learned edition, senior government advocate has entered appearance and accepted notice on behalf of respondent 2 and 3, no formal notice need be served. However, extra copies be. Now, the council will proceed to take a stage for service of notice upon respondent. Respond number 4, the registered questions. It's to August order, what should be done?
There is the interim prayer as well, madam.
Yes,
Because the order itself is illegal ab initio.
status quo. Status quo.
But since
Doesn't
they have
matter.
asked us to go to the civil court, madam, and we don't have that jurisdiction, we cannot approach the civil court, madam. But there is an order
Next
passed by
para,
the.
in the interim, comma, considering that the petitioner has raised an important question of law. And also considering the prime proceed, it appears to be revenue proceedings, comma. The impugned order dated 28/8/2024 shall remain suspended till next, shall remain suspended.
Okay.
I plead.
Yes.
Well, the matter was listed on 25/10/2024,
Yes.
and the respondent, they have taken the time to file affidavit, but then they have not yet filed.
May I, Your
That's-
Lordship?
Yes.
We have not received the paravise reply, Your Lordship, from the department, so at least 3 weeks time may be given.
Heard Mr. S. Mo, learned counsel for the petitioners. Petitioners,
Yes, yes, my lord.
Petitioners.
Petitioner,
only one
only one.
petitioner. On the prayer of MS P. Pang, Learned State Council, list this matter after 3 weeks so as to enable the state to file their response.
Lordship, I'm appearing for respondent number 2, 3, and 5. We are the agency,
Mr. N. Kira,
Lordship.
huh?
And Kira, for 2, 3, and 5, Lordship, Lordship, we are challenging the maintainability of the writ in itself because there is an equally.
This was the same
efficacious-
argument they had last time. They have not yet filed affidavit. If they,
that-
they want
we-
to challenge, you should file affidavit.
Who is the
We-
main
we-
party? Is the
When-
state or you?
When party is the state, not the NAPCO.
Okay, we'll consider your maintain,
Lordship, we are the
submission
main
on the
party
next
who
day.
executed the project, Lordship. We'll file.
Well,
What is the state, not the NSC?
There is no stay. Stay is there.
No, no stay, Lordship.
Continue, go ahead, execute it
No, Lordship, work is done.
immediately.
I see, are already executed. Yeah, Lordship.
Lordship, it is a
They have
matter.
already acquired and they have already executed.
If I may, Lordship,
All I
the
say-
issue is,
Kera, Learned Standing Council for Power Grid Corporation,
Lordship,
Power Grid,
Power Grid Corporation, Lordship. Power Grid Corporation of India Limited, PGCIL.
Power
Lordship.
Grid,
Power Grid, Power Grid.
Power Grid Corporation of India.
Respondent 2, 3 and
Regis-
5.
2, 3 and 5.
submitted that the writ petition is not maintainable. The issue of maintainability is kept open for determination on the next date.
Highly obliged, Lordship.
Like,
Obliged, Your Lordship. May I, Your Lordship, here,
Yes.
so we have not received the Paravas reply, Your Lordship, at least somewhat 3 weeks
What
time will be
Mr.
given.
And as a learned counsel for the petition. Mr. MSP Pango Learned State Council is granted further 3 weeks time to file affidavit in opposition.
Obliged, Your
Lordship,
Lordship.
I'm appearing for respondent 1, 2 and 3 over here, Lordship.
You record and Kera.
And we have already filed our affidavit, Lordship.
That means that for respondent number 2, 3 and 5.
1, 2 and 3, Lordship, in this
1,
matter.
2, 3. Learned State Council for respondent 1, 2 and 3 has submitted that he has already filed his counter, filed the affidavit in opposition. List after 3 weeks.
Highly-
Yes,
Yes, my lord, as per the last order, I have.
you
published
filed
the
an
resolution.
affidavit.
Yes, my lord, I have. published.
File the affidavit.
Yes, my lord.
Have Mr. petition.
Yes, my lord.
Mr.
A Dalbong, my lord.
A.
Dalbong.
Your name is there.
Yes, my lord. Aso Dalbong, my lord.
This is item.
Item 13.
Okay. Learned counsel is that Dalbum. Also the A Dalbum, learned counsel for the petition. Submits that he has filed an affidavit. With regard to the steps taken through the paper publication, which is taken on record. In view of the above. In view of the steps taken through paper publication. The service in respect of respondent number. Respondent number
Respondent number 2, 3, 4, 5.
2, 2. All.
Yes, my lord. Except one, my lord.
2 to
2
8
to 8, my lord.
is completed. List the method for admission in after 2 weeks or 3 weeks, 2 weeks, 2 weeks.
Obliged.
my lord, in 14, my lord, your lordship may see the last order, my lord, is 5/11/2024. In that order, your lordship was pleased to direct to inform case sectioner so that he may represent respondent number 4, 7 and 8. We have served notice through Dusty to respondent numbers 4, 7 and 8 on 29/5/2024. This is my lord, reflected in the order 05/11/2024. And accordingly, I also inform case sectioner. And my lord, registry was also directed to inform the concerned
Yes,
buyer.
where is case sectioner?
He is still not present today, my lord.
The order has also been communicated to him. All right. Heard Mr. S. Mo, Learned Counsel for the petition, and Mr. N. Rathan, Learned Additional Advocate General for the state. As per order dated 05/11/2024. Mr. K. Saxena, Learned Counsel, was directed to inform. Sorry. The registry was directed to inform Mr. K. Saxena so that he may represent respondent number 4, 7, and 8 on the next end. Mr. The said order has been, it appears that the said order has been communicated to the learned counsel, Mr. K. Saxena. However, he remains absent today. List the matter after 2 weeks. On the
State can file a.
on the next date,
Deputy Commissioner has filed.
on the next date, if Mr. K. Saxena remains absent without any intimation, the service of respondent number 4 and 4, 7, and 8 shall be deemed served. Then affidavit has been filed. Just after 3 weeks.
All right.
May I please?
What is this?
Sir, yes, Your Lordship,
A review petition,
only, yes, para 15,
27 days.
27 days delay.
Where is para 15?
The delay of ground is page 4, my lord.
That's okay. Where is para 15?
Yeah, there is paragraph 16 of order dated 24/9.
What's wrong there?
Yes, there is only one correction. my lord.
Yes.
17/1/2004. It should be 5/7/2015, my lord.
5/7.
5/7. This much only correction, my lord. So we are
What
immediately.
what is to be corrected? Page 14.
Page 13, my lord. Page 13. Paragraph 16, my lord.
16. That
Yes.
is in this in my in record it is page 14, para 16.
Or
It should be corrected as
S 05/07/2015.
it's correct. It's written as 05/07/2015.
There is two order, my lord.
Huh?
Another order is there, my lord.
Which one?
11, I think, item number 11. It's an analogous method, my lord. Item 11 and 12.
This is in IA 228.
Yes, 228.
228. Is it 228 or what? Which you are referring? It's IA 228.
Yes, my lord.
Yes.
This is IA is only for condonation.
Yes.
The
What is to be corrected?
In my review petition 12,
What is 12?
review petition 12. my lord.
Yes.
Yes, my lord.
Page
Page
13.
13, my lord. Paragraph 16, my lord.
Yes. It should be
It should be in place of 1/7/2014, it should be 05/07/2015.
it's 05/07/2015 only, sir.
What in my
Last line. 05/07/2015.
oh my god, it's correct only. But in this next case. Yeah, item number 16. Sorry, my lord.
What is to be done in this?
It is okay only. Sorry.
Then you withdraw. You withdraw then, if it is correct.
I'm withdrawing.
Perhaps this thing, huh? Both the thing. IA also and Mr. Udeka, learned counsel for the applicant. Press for withdrawal of the IA. Being IA 2 to 8 of 2024. Accordingly, the IA stands dismissed on withdrawal. Then review petition 12, huh? That also same. Press for withdrawal of insurance. Dismiss on withdrawal. Yes. Here, which page? Yes, 17/1/2014.
My lord. 17/1/2014 should be 5/7/2015.
Why?
Because as per lower court order, generally interest imposed upon from the date of filing the claim petition.
Yes.
So here date of filing petition is 5/7/2015, my lord.
Then why this 17/1/2014?
17/1/2014. I think
Has come from where?
typographical mistake, my lord.
Are you sure?
My lord.
Where is that judgment and award?
Judgment and award, my lord, page 23.
23.
Yes.
Yes, till full and final, the amount of the interest at 6% from the date of filing the claim petition. Yes.
This must only, my lord.
Okay. So here is there any, so, okay. IA 229, right?
Yes, I 229 is the same only with the withdrawn petition.
You read heard Mr. Udeka, learn concept of the applicant by filing this application under section 5 of 20 Limitation Act 1963. The applicant has paid for condemnation of 27 days, condemnation of delay of 27 days in filing the connected review petition for correction of typographical error of the judgment and order dated 24/9/2024. Passed in. What is that? Passed in MSc Appeal 25 of 2018. Next page. Since the delay is of 27 days and no prejudice will cause to the respondent, public claimant, is appears that the review sought for is for correction of the date of filing of claim petition, which is inadvertently mentioned as 17/01/2014 at para 16 of the judgment and order dated. It said judgment and order passed by this court. And also considering that the delay, the cause shown by the applicant is sufficient, which has prevented the petitioner, the applicant to file the connected review petition, being review petition number 11 of 2024. The delay of 27 days is condemned. Next. The IA is allowed and disposed of in review petition, huh? Heard Mr. Swenson learned counsel for the petition, review petition. This is an application for review of the judgment and order dated 24/09/2024, passed by this court. In MSc appeal 25 of 2018. Mr. Considering that the review of the considering that the application for review is to the extent of correction of typographical error which has been inadvertently recorded at 17/01/20. No, which has been inadvertently recorded the date of filing of the claim petition as 17/01/2014, which the present review petition is considered and disposed of without issuing notice to the respondent oblique claimant as no prejudicial cause to the respondent. Next paragraph. Having considered that the this court, while disposing of the above MSc Appeal 25 of 2018, at para 16, inadvertently, the date of filing of the claim petition is recorded, has been recorded as 17/01/2014, which ought to have been as 05/07
Yes, my lord.
2015.
051.
This review petition is allowed, and accordingly, the typographical mistake occurred at para 16 be read, showing the date of filing the claim petition as 17/01/2014 be read as 05/07/2015. This order shall be part of the judgment and order dated 24/09/2024. The review petition stands allowed and disposed of. Yes.
Highly obliged.
May I please, Madam?
Yes.
Madam, the respondent number 6 of the matter writ petition has filed instant I application for modification of my lord's order this honorable court's order. But to find the order is at page 14 now. As relevant part is at page 15.
15.
The last paragraph. The respondents shall not issue the work order for construction of Sario to Saria Takang by package number such as till the next returnable date is not issued. And subsequently, these interim order were extended till the listing of the writ petition matter. My lord, the tender NIT was issued for my lord, connecting the villages, one village from another village in the border areas, my lord, for which NIT was issued to be, the said project was to be completed within a period of 18 months, my lord. And accordingly, the writ petitioners and the respondent speaker 7 along with others have submitted their bids, my lord, pursuant to the NIT. And my lord, ultimately, by the opening of the technical bid, the petitioners, my lord, bid was rejected, my lord. Lordship, that will find at page in the manner writ petition, my lord, invoking, my lord, 3 clauses, my lord. One of the main clauses is that, my lord, they have not filed the affidavit supporting their filing of the documents as required under the SBT, my lord. On these grounds, his case was rejected, the bid was rejected, my lord. And financial bid was also opened and recommended the respondent number 6 and 7 for finalization before the authority, my lord. My lord, at this stage, I am only seeking that, my lord, similar, my lord, facts and tenders, my lord, same nature of works, my lord. My lord has particularly, my lord has, this honorable court has declined to, my lord, interfere in these situations, my lord. Lordship, I have annexed those, my lord, orders also, my lord. Lordship, kindly see at page 20, my lord.
Yes, I have seen it.
These are all subject to outcome of the writ petitions, my lord. But admittedly, his rejection will be considered by this honorable court, my lord. But till then, my lord, the work cannot be stopped, my lord. It is in public interest. That too, in the further, my lord, remote border villages, my lord.
May I please, your lordship? Your lordship, I am for the respondent in this IA, your lordship. I'll be filing reply, your lordship.
Yes, what do you say?
My lord, the ground, we have already filed affidavits. The ground on which the technical bids of the petition now respondent was reasonable. So he is also undertaking a construction of a secretariat at Raga. That information was not furnished in the technical documents. So it's 4.7 clearly attracts. So he have suppressed certain facts. So thereby it caused difficult for calculation of the bid capacities. So he have not furnished all these ongoing projects. So there is reasonable ground. So unless the ground which the technical bid was rejected is unreasonable, the court interference is very limited. My lord is aware of that. So similar packages in respect of East Coming district, all the packages there is no stay order, but except this. So now it affect the, now working season is almost finished. My lord is well aware in Arunachal Pradesh. There are rainfall more than 6-7 months. Now December, October, November, December, January and February.
Yes, you are not eligible. Your bid has been rejected.
Your lordship, I will be given opportunity to file reply, your lordship.
Friday. These are all similar.
Yes, vibrant
Other is
village.
same, vibrant.
Vibrant village.
This is only the one exception.
Subject
There too without any reason. There is no reason. The learned counsel shall obtain necessary instruction, produce the records pertaining to NIT, which is for construction. So these responsibilities, there's no reason. There's no reason, or it's not a reason order to, staying the issuance of work.
And as of now, we have already filed our affidavit also.
Yes. We'll complete, hear the matter on Friday.
Friday, Your Lordship. 6th.
It's better to dispose of the matter. It's a tender matter. In case if we cannot take it up, we'll consider this IA on
Yes,
Friday. In case if we cannot, if the matter cannot be taken up for final disposal.
29. Your Lordship, Your Lordship, it would not possible, Your Lordship. The leading counsel will, on 29, Your Lordship, he
Who?
will not available, Your Lordship.
Who?
Mr. Tapo, Your Lordship.
Where is it?
He is preoccupied, Your Lordship, on that day, Your Lordship.
You request him to come?
Your Lordship, then if possible, Your Lordship,
See,
third,
there is no reason not to issue work order. There must be some reason why work should not be issued, work order should not be issued.
true, but Your Lordship.
They have filed an affidavit now, making this their stand clear.
Your Lordship, kindly accommodate on 3rd, Your Lordship, 3rd December, then.
Then my lord, let the, my lord, stay be modified, my lord, to the extent it's subject to October. And short.
They want to file an objection. They will
We have on next date, my lord.
tomorrow they'll say no again.
Your Lordship, by 3rd, we will file reply, Your Lordship. By 3rd, Your Lordship, 3rd of this.
What reply?
In this IA, Your Lordship.
IA, what is there? IA
If necessary, Your Lordship, if
no reason,
necessary.
it's not a, there's nothing why the work order should not be.
Yes, Your Lordship, if necessary, Your Lordship.
We'll take it up on Friday.
Your Lordship,
Is
kindly
it when,
please, Your Lordship.
you-
He is preoccupied, Your Lordship.
Find a counter affidavit, my lord. Till today, my lord, till date, my lord, he has not responded to our counter affidavit.
You try on Friday. We'll try on Monday.
Friday, that is the Friday I have some difficulties. On first I have some program at my place, so I am leaving.
Third,
That,
Much
or
obliged.
Mr. Arsakia, Learned Counsel for the petition. This is an application for modification of the alteration and or vacation of the interim order dated 28/08/2024, passed in WPC number 354 of 2024. Wherein the respondent authority has been directed not to issue a work order for construction of LO 26-2 Saria Takang. In connection with what is this? With package number AR 03 01058 till the next date of the till the next returnable date. No, not till the package so and so, huh? Pursuant to the NIT dated. What is the NIT?
3/7/2024.
NIT dated 3/7
2024.
3/7/2024. Next, this is the matter on Friday.
On Friday.
Your Lordship,
Or
kindly
third.
please. Third.
On Friday, my lord.
Friday, he said he's not pushed. Third, in that case.
Much obliged.
This is the matter on the third. 03/12/2024. The learned counsel with the petition oblique respondents may file their objection, if any, on or before the next date of listing. You all item 21. Sir, we'll take up your case later. There is a pattern matter.
This is also part of.
This is also pattern.
Yeah,
No, it doesn't indicate.
no, it was part of, it was hard on
Let
9
us see.
2024. And
This court it might have had it part incomplete.
incomplete.
Thereafter,
Lordship,
it was listed
Lordship,
again.
your word, Lordship. On 9/9/2024, Lordship, it was left part third, Lordship.
No, it says remains inconclusive. Thereafter, it was listed for 4 times, 3 times in a different court. It's not partner. That day, I think I remember, I've heard you, but it remains inconclusive. So it was listed thrice thereafter before another bench, but could not be taken up. We'll take it up. We'll see. Since this is listed, we'll take it up, but then see, it's not part hard. So we'll give the first preference. Orion Health.
My lord.
Yes.
So that, in the tender, my lord, it is annexure 3, page 75, is regarding ready-made food, my lord.
Page 75.
75. Items are rice and pulse based energy food with minerals and vitamins, kheer ready to generation and purified rice and fortified minerals. Now, one of the so far
Same tender.
same tender. Same tender.
What is your grounds? That's
Yes,
all. If you have initial ground, you just
Yes,
give
my
us.
lord, I'm.
Otherwise, it's the same tender.
Yes, here also see, my lord, that qualification points you also see. Now, in the reply, my lord, they have annexed the minutes of the meeting that I want to place. Why, my lord, they have, they wanted to state reply.
Page.
Reply, their appeal opposition, my lord, page 20. That's one of 1 to 3.
Affidavit in opposition.
Yes. And it's just.
1 to 3.
Yes.
Yes.
Page 20 also document.
Yes. Yes.
Well, I'm reading that second paragraph, they have tender documents of other states they have taken. Then on going through, well, real office.
Yes.
Going through the terms and conditions and other eligibility criteria, it is observed that many of the conditions are similar in all model tenders followed by other Western states. Over and above, all the terms and conditions, Meghalaya state is following marking system to qualify tender. Well, this is what it has prompted them, my lord. After thorough scrutiny and discussion among the members of the committee is of opinion that logical to adopt the two-bid system, bid and financial bid for inviting tenders in WC department for procurement of essential foods. It also found that marking system is also a good procedure to finalize the best exchange bidder subject to the inclusion of the following points. Here, my lord, you will also find net worth of bidder, they have said 2022 audited balance sheet 20 crore, 5 points, so and so. Well, that clause, my lord, in the. Then finance activity certificate issued during the current financial year, April 23 onwards, 5 points. Well, these are the two conditions they, my lord, wanted to incorporate. My lord. Now, against this marking system, my lord, we have submitted a detailed, my lord, response. In the detailed response, my lord, they have given the reply. Well, that reply I want to place, my lord, annexure B of their affidavit motion. Page 18. I shall make it very short. The para 2, I am not, first one is the GST return, my lord, I am not going to say anything. This is the main customer. The net worth of bidder as an indicator of financial health. The overall value of the contract may increase to a certain extent during 1 year, subject to number of beneficiaries and amount of funds released by the ministry. Once contract is awarded to a successful bidder, the bidder has to employ its own funds to manufacture, deliver, and supply the food items continuously at the change destination for a period of 1 year, which may extend to another year or till the finalization of the contract or same rate terms and conditions. The payments of selected bidders shall be released after a successful completion of the contract. Payment may be further be delayed depending on the receipt of fund and the government of India as well as state government, but unlimited supply has to be ensured for a successful bidder. So the department felt the bidder to financially sound, capable to execute the unlimited supply of food items which are urgent nature for distribution among the vulnerable sections of the beneficiaries, including children, women, when then the release of the payment is not released. Therefore, the department decided to give opportunity to bidder who had better financial standing to handle the financial issue. However, anomaly in clause 21(1) for terms and conditions of the qualification number 8 is taken note of and corrective action will be taken. The draft corrigendum is already in the process of obtaining approval. Well, the corrigendum has been issued, my lord, prior to this letter. Anyway, my lord, now, my lord,
This is by Government of India.
Yes. Yes. No, no. This is the
Joint Secretary.
Yes, yes. Honorable Joint Secretary. Well, this is the reply. Well, can it be justification for this, my lord? My lord, in the last tender, the value of the supply was 20 crore and the net worth was fixed at 15 crore, my lord. And in the 2018, just, my lord, same thing, my lord. I'm just giving a copy of the same, my lord.
What does it indicates?
I don't understand. They say, well, I have submitted my this financial help, my 20 crores odd. They require only 10 crores. And that is given in the eligibility criteria as well as terms and conditions also. 10 crore. They want 10 crore.
What is this? This is
The last tender in 2018, where my lord, the total amount is 20 crore, and they require, my lord, the 15 crore. If your losses comes to, my lord, page 6, clause K. The net worth of the tender is 15 crore, not less than 15 crore. Whereas the supply is of 20 crore.
This fine.
Supply is of 20
Net
crore.
worth of tender shall not be less than
15 crore. This was the
this is for
last tender. This was the condition, my lord, and this tender is now still going on.
No, this was for
last year.
Last 2018, same.
This one.
No, this is same same estimate cost.
Yes, same, my lord.
No, this is the estimate cost of what?
Estimate cost is, my lord, 20 lakhs. 20 crore.
20 crore.
Yes.
Here also 20 crore.
Here 10 crore. Here 10 crore.
So what you are trying to say is, since it was in last tender, estimate
Supply was 20 crore.
Supply of 20 crore and
net worth was required.
Net worth is equal to 15 crore, and that contractor is still supplying.
It may not have any bearing.
Clear, my lord.
Up to them now. By next date, next year they have some. They have some other reason to have increase the net worth.
Can it be a, my lord, ground, my lord, that it may be because my net worth what I have given 20 crore and odd. This up to 24 if they take, it will be 30 crore, my lord. That is not a question, my lord. Here, my lord, the main question is this. Supply is
so why by showing this in the last tender, the estimated value was of 20 crore, but then the requirement of net worth is 15 crore. Now the present one is 10 crore, but requirement is 20 crore.
Yeah, no, they even value, my lord, up to so and so, up to 35 crore.
Yeah.
My lord, that is the
what they are saying to say is, if you have this net worth,
yes,
the points will be given.
No,
that's what they are saying.
Why? But points, my lord, because in the eligibility criteria and general conditions, if you also see conditions, my lord, they have given that what, my lord, how much is required. If you also see, my lord, page 80.
Just do it. Yes,
Page 80, clause L,
80.
80.
Amended petition or?
My petition, amended. Clause L, net worth of the tender shall not be less than 10 crores only, as on 31/3/23, as reflected about this balance sheet, 11 certificate of good funds. So, they have given these terms and conditions. Now, what a question of qualification points. Well, that is my question.
So basically you are challenging the
that
qualification
is
points.
that.
You could
And
not have.
moreover, my lord, the states is added by again another. In the minutes of meeting, the states was not there. If you also see, that was not there.
But
the
sir,
states-
it applies to all the bidders.
Well,
Not only to you, also applies to all the bidders.
that is the.
If you have unfortunately doesn't have that much of a net worth,
They
what
wanted
can
to-
we do?
They have already picked up the persons to whom my lord,
That you have to
that is-
establish.
I'm self-placed, my lord.
Otherwise, to have the better, I mean, financial status, I mean, having that
If you
financial.
also see, my lord, page 98, my lord, that again, qualification points, but only mainly 5 and 8. I shall place again.
Yes. 90?
98.
98. 98.
98. And 30.
Yes, I've seen it.
My lord,
On the-
here you also see in the minutes of the meeting, my lord, they have suggested for these points only, this
I was not suggested.
this state is not suggested. In para 5, my lord, they have not suggested for the inclusion of the states. This was included by the authority only, later on.
5.
5, this was not there. One state, 5 point, 2 state, 10 point. I do not understand, my lord, how, what is the restriction for inclusion of this? Then this clause 8. You require the supply of 10 crore, and here you have said up to 20 crore 5 point, 25 crore 10 point, 30 crore 15 point, and 35 crore 20 point. I don't understand, my lord.
Sir, this we can understand.
My lord.
All can understand, but
Yes.
problem
The
is.
blue-eyed boy is there, my lord, they wanted-
Why there is a problem is that last line,
Yes.
that minimum points.
My lord, that's it, 90 points. So
This is-
any person, my lord, who, my lord, has 30
Minimum
crores of-
points required for qualification and tender bid is 90 points.
Yes. If a person is
This
supplying,
creates a problem.
yes, 2 states is supplying, even then he will be out. No, 90 points, why, my lord? This is the main crux of the matter. They wanted to pick up the person to whom the contract will be given. My rate is much lower. I have
Other
given-
day we tried to
yes, I have
ask
given.
explanation from
Yes,
the
my lord.
state.
I have, my lord, mentioned my rate also, which is less than here. Page 26, my lord, if you'll also see. Page 26 of the arbitration. I've said, my lord, my rate is much lower than the responder of 6 and 7.
Page number?
26. Yes, rate quoted by responder 6, 91, rate quoted by responder 7, 89, mine was 83.80. Similarly, 149, 149.50, my is 140.50. This third item is same, my lord, page 27. 170, 169.90, my was 160.
It is present rate.
Very different, my lord, but they, for what in whose interest, my lord, they are issuing a tender. Tender is meant for that, my lord, that they must get the competitive rate. There should be more tenders, my lord, so that rate can be competitive. That is why, my lord, Supreme Court has said, my lord, I am just.
So you have not participated in the tender?
Yes, I have participated. Only on 90 points, my lord, but my foods and other thing has been certified. Everything okay. But only on the.
It has
point-
been rejected.
Yes,
It has been
yes, I
rejected.
will. My lord, that has been. Your losses may come to my lord, page 106. 108. 108, my lord.
Okay.
My lord, serial number 4 rejected, and ground, and my lord, I shall come.
So you are
The ground, my lord, has been given, and 90
What-
points have been not used.
6 and 7
Yes,
have been
yes,
awarded.
not awarded. They have to stay there, my lord. Stay is already there,
Okay.
my lord. And
Admitted,
because I have not received 90 points.
109, page number 1.
Page 109, my lord.
103.
103, my lord. Page 103, if it also is fine. Hmm.
Yes, 103.
103. The last item, my lord. So far, food items are concerned, there is no comment, my lord, because same thing. Only last minimum qualification points 90 has not been scored by the bidder. Only on this count. This is what, my lord, I am submitting, that what they have meant. Actually, my lord, they have in their mind that they wanted to give this contract to those particular parts. There is no justification for the same, my lord. In this aspect, however, I say place, my lord, 3-4 decisions only, then accepted. My lord, first my judgment is latest judgment 22/6 SCC 401, my lord. I am giving a copy of this.
22,
6 SCC
2022.
2022 6 SCC 401.
Yes, paragraph. Para.
Para, my lord, I shall come directly to para 29. 448. My lord, various decisions have been considered by this court. My lord, if your lordship come to my lord first at page 444. Last, my lord, is subparagraph 22. After considering the Jagdish Mandal, Tata Cellular case, my lord, they have come to this. Judicial review, your lordship got it, my lord? Judicial review of administrative action is intended to prevent arbitrariness.
Sir, why we should read this?
My lord?
Why you should read all this thing?
Yes. Now your lordship might just come to 29, para 29.
Yes.
This, after considering all these, my lord, this court has come to this conclusion.
29.
Page 448.
448.
Yes.
Thus, from the aforesaid decision, it can be seen that a court, before interpreting the contract, can exercise the powers of judicial review, should pose to itself the following question: whether the process adopted or decision made by the authority is melancholy or intended to favor someone. This is, my lord, I'm having. Intent to favor someone, or whether the process adopted or decision is so arbitrary irrational that court can say that the decision is such that no responsible authority can act reasonably in accordance with the relevant law, which could be reached. Whether public interest is affected. Yeah, public interest is also affected, my lord. My rate is much lower. Article 39C.
How do you know that they are intended to favor someone?
Well, because this points is, my lord, that is why they have said that minimum 90 points is to be achieved. Nobody can achieve except number 6 and 7.
How do you get it?
Well, because they have the network of, my lord, 35 crore. They are supplying to other states as well.
That's what I'm saying.
That is why, my lord, they have intended to that.
That's
Your losses will see for the supply of 10
if you
crores.
don't have that much of network.
Well, why it is necessary, my lord, to supply in Arunachal Pradesh?
And if someone, some bidders are having a network, that
My
much
lord,
of network.
my lord, the qualification of points has nothing to do with the tender, my lord,
See,
actually.
sir, look at this.
Tender has been especially said that I require, my lord, my 10 crores. My network should be 10 crores. Tender, once requires.
That's why.
That 10 crores. Well, I have to more than 20 crores. But this year I shall be more than 30 crores.
Because all the firms, all the companies are not having a good person. They are not having a equal persons.
My lord,
somebody is having a better person, somebody has a bad person.
No, that is why I am submitting, my lord, that eligibility condition and terms and tender conditions are very important.
Yes.
Here they have said that. Then again, additionally, they have added this qualification point. Why, my lord? This 90 points, why they have to receive? Why 90 points? If a person, my lord, supplies to two states also, he is out.
So we'll
Even
ask,
if he has
we'll ask from them.
my lord,
But you have to establish that this
this is intended to, my lord, favor respondents 6 and 7 on the face of it.
just because they are having a better position,
My lord, no,
they are more
they have the
more rich than you,
network. Yes,
richer than you.
no, that is not the question, my lord. I am submitting, my lord. Then I shall place, my lord, another judgment. That is
Yes.
23 to SCC 703.
2023.
23.
3 2 SCC.
Yes, my lord, 23 to SCC 703.
Yes.
Yeah, I
Para?
just given a copy of this. Paragraph 58, then, my lord, 73, 74, 75, 4 paragraphs.
74, 75. Yes.
My lord,
Yes.
after following this Mahavir Otto, my lord, the para 12, my lord, sub para. It is well settled that every action of the state or instrumentality of the state in exercise of a huge power must be informed by reason. But is it a reason, my lord, they have given it? My representation, my lord, has been disposed of by saying that it may increase. Well, can there be, my lord, a ground for saying that 35 crore in respect to 10 crore? In appropriate case, action uninformed by reason may be questioned as arbitrary in the proceeding under Article 226 or 32 of the Constitution. Relying in this connection may be placed on the observation of this court in direction of the appears to us that in the facts and circumstances of the case, respondent company IOC is an organ of the state or instrumentality of the state as contained under Article 12 of the Constitution. The State Act is executive power under Section Article 298 of the Constitution in emerging and not entering into contact with individual parties. Article 14 Constitution would be applicable to those exercises of the power. Therefore, the action of the state organs under Article 14 can be checked. But Article 14 of the Constitution cannot and has not been considered charter for judicial state action after contract has been entered in or to pull upon the state to account for its actions in meaningful activities by stating the reasons for such action. In such a situation, this nature, certain activity of respondent company which considered as state under Article 12 of the Constitution may be in certain circumstances subject to the conditions of entering into or not entering into contracts and must be reasonable and taken only upon lawful and relevant consideration. It depends on the facts and circumstances of a particular transaction whether a hearing is so this is matter. Now your lordship may come to para 73. What's the arbitrariness, my lord? That has been defined here, my lord. This court in Sri Lanka, Vidyarthi, state of UP, held that every state action in order to survive must not be susceptible to the vice of arbitrariness, which is the crux of the Article 14 and basic rule of law. The system which governs us arbitrariness begins with negation of the rule of law. Non-arbitrariness being the necessary component of the rule of law is imperative that all actions of every public functionary in whatever sphere must be guided by reason, not humor, whim, or caprice, or personal elections of the persons entrusted with the facts of on behalf of the state and exercise all powers must be public good instead of being the abuse of the power. Yeah, abuse of power, my lord, not public good. Then 74, my lord. The next law dictionary has also been considered. There are 74, my lord. We may notice. Next page. 74. Next. 74. We may notice what arbitrariness held the consideration of the court in the case of involving the examination held in a recruitment process in East Port Railway. So and so. We notice the following case. Black Law Dictionary describes the arbitrary in the following. Arbitrary, depending on the individual discussion, specific direction by the judge rather than fixed rules, procedure, or law, founded on the prejudice or preference rather than the reason of type of decision was often termed as arbitrary and capricious. To the same effect, the meaning of the word expression, arbitrary, like first jurisprudence, which explains the term following word. Arbitrary based upon one's will and not upon the force of reasoning and exercise of judgment bound by no law. Capricious and exercising according to its own will or caprice. And therefore, conveying a notion of tendency to abuse the position of power, fixed or done, capriciously, principle, not rational or not done, or acting according to a reason or judgment, not based upon actuality, but beyond a reasonable extent. Not found in the nature of things, not governed by any fixed rules or standard, and also in somewhat different sense or abuse of power, despotic or tyrannical, harsh or unforgiving. But when it applies to acts arbitrary, has been held to not disregard the evidence of the proper way thereof to express an idea exposed to administrative, executive, judicial, and legislative discussion, and to imply at least one element of bad faith and has been compared with good. Then arbitrariness, my lord, has been defined more, my lord, gets compared 23 and to 75, paragraph 75. We will therefore sum up that when an act is treated as arbitrary, the court must carefully attend the facts and particular case. It should find out the income decision is based on any principle. If not, may unerringly point to arbitrariness. Well, what is the my lord? What is the principle what they have given? They say, my lord, it may increase quantity, only that, nothing more than that. Then again, if not, if act betrays caprice the mere exhibition of whim of the authority, it will be sufficiently bear the insignia of arbitration. Then last again, few lines, my lord. It says, if there is absence of good faith and the action is executed by oblique motive, my lord, it could be characterized as being arbitrary. Well, here the motive is on the face of it. Well, 90 points. Why 90 points is what? Well, that is my question, my lord. This is what is by the doctrine of unreasonableness, my lord. This is this. Okay. Then, my lord, I shall place another addition. Our High Court decision has been placed by the doctor also. I am giving a copy of the statement. The 2003-1 VLR page 581. So your losses has, I think, gone through this paragraph. Your losses may just not down, paragraph 36, 38. 36, 38, 39, 42, 43, and 49.
Yes,
I shall read.
Yes, please this.
Only paragraph 38 I shall read, my lord, because that was not there on the day.
Paragraph 38. What is the paragraphs?
Other paragraphs are 36, 38, 39, 42, 43, and 40.
42 and 49.
Yes, sir. 42, 43, and 43. Paragraph 38, my lord, at page 594. The matter of common knowledge that school uniform.
Yes.
The matter of common knowledge that school uniform is required to teach as per the measurement applicable to each individual. Therefore, it is not understood as to how and why a textile mill engaged in the business of manufacturing clothes has been found to be more suitable for manufacturing school uniform. So this is what there is no discernible reason as to why the respondents have to choose owner of the textile mill over with over 100 crores turnover, so prepare to panel of suppliers.
Last part.
39 last part only, my lord.
Mere presumption.
A mere presumption, the last line. A mere presumption that smaller business group would fail to deliver the good quality items, which in this case is merely school uniform, cannot be the justification for excluding such entrepreneur from the realm of the contract.
But here is supply of food items.
Food item will 10 crore. My lord, that it's 20 crore. What is?
It is different
Yes.
from school uniform.
Maybe, my lord, I'm just giving, my lord, and moreover, this, para 49, my lord. 43 also. 43 also there, my lord. Instead of posting, I find that eligibility condition of the UI has been designated in fashion that to ensure that the supply orders are received by only a few composite textile mills to the exclusion of all others. This is 90 points, my lord. Why 90 points has been given, my lord? And this is, my lord, actually, Honorable High Court, direct judgment also, my lord. I'm just giving it. Let's see that 2000, year 2006, 2006 1 ALD, page 12.
ALT,
ALD, my lord.
Assam Law Times.
Under Pradesh law type. Oh, Under Pradesh law. I said, place only one paragraph, paragraph 35.
Just read it.
Only paragraph 35, your lord. Here, they are also same, my lord, point was involved, my lord. Paragraph 35, last page.
35.
Last page. The committee which evaluated the tender identified 8 other qualifying conditions besides 3 mandatory criteria. Curiously, while allotting marks, the mandatory criteria as discussed above were allotted low weightage, and for other qualifying conditions which were described in the tender notice as desirable or preferred, qualifications were given more weightage. This is what, my lord. Same thing, my lord. This is certainly irrational. It is accepted position of law that when essential qualifications are prescribed and incidentally it is specified in the given that a given additional qualification or criteria is desirable for a person which has specified additional criteria or qualification would be preferred to others. It only means that in the event of 2 persons achieving a similar benchmark or above benchmark, the persons with specialized additional qualification or criteria would be selected subject to other conditions of compliance. Here also same thing, well. In the method adopted by the Tender Evaluation Committee, however, the principle was ignored, and therefore, this is one area where decision-making process suffers from incurable defect.
Period 35 or 39?
35. 39 is the portion, no?
No, there is no 39.
Is opposite portion.
There is no 39.
No, not that, 35. 35, my lord. Another, my lord, earlier decision also I can rely on, my lord, if you also see.
I think it's okay. It's more than enough.
Which second paper?
That has all been considered.
Yes.
In 2022, 23, 24.
My lord, only I am giving you notice, my lord, the paragraph also all
considered.
Paragraph 23 and 24, my lord. So my humble submission is this, my lord. These additional conditions.
These all been referred in 2022, 23.
My lord. But actually, these are referred, my lord. So my only submission is this, my lord. These qualification points are added with the intention that the 2 persons should be given the content to the exclusion of others.
No,
although
sir, that is what I'm asking.
Yes.
How? You show us anything?
Yes, I have shown, my lord, because the reply I have given, my lord, their reply is this, then the contract may increase to a certain extent. That is the page, answer B. My lord, page 18 of their reply. Can they pay ground, my lord? They may get more funds from the government of India. My lord, this is not the ground, my lord. For achieving 90 points, that to 90 points. This is only in respect of, my lord, this financial health. What is about the states? That was not in the Manchester meeting also. Manchester meeting also not saying that the states should be added. 1 state, 2 state, 3 state, 4 state, 5 state. That's not there. So, mother, this cannot be ground, mother, that the value may be increased. Well, even in other tenders, road tender or bridge tenders, my lord, always, my lord, additional works are allotted. They have to give it, my lord. Montage value may be increased, my lord. That's not a question, my lord. Here, my lord, the goods are supplied, my lord. Monthly quota is given, monthly. Monthly again, that payment is being done, my lord. So when the question of, my lord, even if suppose 10 crores becomes 12 crores, nothing it will disturb, my lord. Nothing will be disturbed. my net value was given in 20 more plus crore. So this 90 points has no justification at all, my lord, what I am submitting.
Yes.
This conditions has been added just to, my lord, with the intention, just the two blue-eyed boy.
To favor the respondent 6 and 7,
6 cents.
who is much wealthier than you.
My lord, yes. My lord, that is the only thing, nothing. Just in the Justice Suman Shyam's, my lord, judgment, he has said that why these bills should be brought to the exclusion of the other, my lord, tenderers. When it is a supply of the only this. This is, my lord. So, my lord, my humble submission that this annexure that should be passed, my lord, qualification points as well as the corrigendum should be passed, and they may be directed to consider the tender in accordance with law, my lord. Because tender, entire tender, my lord, need not be cancelled, my lord. Because already tender has been here. My lord, only after passing these qualification points and the corrigendum, my lord, they may be allowed to consider.
We'll continue it.
My lord, I'll just wrap up within 2 minutes, man, because.
I have a meeting at,
Okay.
it's 1 o'clock. Spare time for two. Yes.
Well, before answering to what the London Senior Counsel said, may I just take to your lordship to page number 26 of the petition, my lord.
Yes.
Well, these are the rate bid by the private respondent as well as the petitioner, my lord. Then you lordship may kindly note one thing, my lord. They have accepted that they have quoted below 5%, my lord. It is stated herein that the rate quoted by the petitioner is approximately 46.8 lakhs below 5%, my lord. Now, when you say it's below 5%, my lord, is what you can say? The quality of supply, my lord, you can imagine, my lord. If it is below 5% from the
Below 5% of the rate quoted by the respondent, private respondent.
my lord. Correct. Correct, my lord. Now, another important thing. Now, this petition was filed on 12/3/2024, my lord. Then, financial bid was opened just after 3 days, my lord, 13/3/2024, my lord. Now, my lord, how this figure they have collected, my lord, on what basis, either in RTI or what basis? Because so far, my lord, NIT is concerned, till NIT is completed, these are the secret documents, my lord. Even RTI will not apply, my lord. The how they got this figure, my lord, that they are below 5% in comparison to private respondent. Number 1 point. Then, number 2, my lord, the last time figure, which the London Senior Counsel was showing, my lord, there, my lord, the total work was more than 20 crores. That's why, my lord, net worth of 15 crores was sought for. And here is the, my lord, 10 crores. That's why, my lord, 5 crore net worth was called for. Now, in commercial terminology, when you say, my lord, net worth, after deducting the liabilities of the company, the rest amount is a net worth. The financial strength of the company, my lord. There, my lord, we can judge whether he's a fittest, my lord, farm or not, my lord, to carry out this contract, my lord. Now, how, my lord, this annexure B that we have incorporated, my lord, that column 4, 5, and 8 are irrational, my lord. My lord, we have justified saying that, my lord, this we have got inserted because to safeguard, my
my lord, the supply chain of the my lord, food grains. My lord, it cannot be compared with the uniform, my lord, where the London Senior Council are referring, my lord. Supplying uniform and food grains are obviously two different, my lord. Because in food grains, my lord, we need to be very careful and we must give the contract to those farm, my lord, who has my lord, financially strong, my lord. Because these are the centrally sponsored scheme. And it may happen, my lord, they have to wait for 5-6 months, my lord. And during that hiatus period or waiting period, the supply chain should not be break, my lord. That is one of the reason, my lord, why this sort of condition are put into, my lord. They have not demonstrated, my lord, how this is my irrational, my lord. Now, what exactly they are saying? That we have tailored the terms and condition in such a way that it will suit only the private reservoir 6 and 7, my lord. Can it be justified to say somebody qualifies as per the terms and condition? Can anybody say that we have tailored the terms and conditions in such a way that it will only suit 6 and 7? Your Lordship rightly pointed out, they are more, my lord, in common terminology, richer than the private petitioners, my lord. Their financial sound is better than, my lord, this present petitioners. Now, even, my lord, in contract, is a state largesse. Now, what they have to demonstrate is the discrimination, my lord. They have not demonstrated discrimination. They have not demonstrated how this is arbitrary, my lord. Can it be arbitrary, my lord, because somebody qualified in the tender? That cannot be, my lord. Even in contract, my lord, your lordship ever, even the article 14 and 16, they keep say this test, my lord, because it's a competitive. You have to be in competitive. It's not that if A qualifies, you have to be also qualified under article 14 or 16. My lord. That cannot be, my lord. So, my lord, to wrap up my argument, my lord, nothing informative, my lord, either in the addendum or that annexure B, which was a part of the NIT, my lord. And so far, my lord, minus of the, my lord, that meeting they have referred, my lord, that is not under challenge, my lord. There shouldn't be bother your lordship, my lord. They have not challenged that. And there also, my lord, they have justified. Because this has been applied in the state of Meghalaya, my lord, and they have carried out successfully. So we are also adopting, my lord. Nothing wrong is there. Well, adopting someone, my lord, good policy may have some, my lord, consequential, my lord, favor or unfair effect. Obviously, there may be, my lord, side effect will be there, my lord. When
It's high time you devise your own policy rather than having a copy paste.
my lord, is always wiser to abstract the good one, my lord, not the bad one, my lord. Abstract the good one, my lord.
That's all.
That's all, my lord. Then, my lord.
First thing first, this writ petition amendment was filed on 24th October.
Yes.
2024. Affidavit says so 52, page 52. And your financial bid was opened on
At page 107, my lord. That is there, my lord. Page
It was
107, my lord, that was received by us.
No, financial bid as per my lord instruction 15/3/2024, right?
No, after amendment only.
Yes.
That was.
No, after amendment, correct. But my question is, how did you get these figures, my lord? Because
This
tender
page 107.
107.
of the amended petition,
Writ petition, yes. Amended writ petition.
107.
That could be the one of the reason they have, they might have amended the writ
Yes.
petition.
Not that visible. Price.
Continental
No, my question is simple, Mana. How did you prepare this document? Because NIT process is yet to complete, my lord. During the process, my lord, even the right to information is not applicable.
summary, is it how much of the tender summary?
Huh?
They're all uploaded.
No, that's all right. My question is only how did you procure this document?
Yes, uploaded, when uploaded. Yeah, uploaded.
Digitally signed.
All digitally signed.
Have you shown that your turnover, net worth and turnover?
My lord, here I have not shown, but I submitted my lord 20 plus.
Net worth. Net worth.
20 plus.
And
So 20 plus means
and then turnover.
My lord, and
Turnover.
only 10 crore. 10 crore.
no, no, turnover.
Oh, turnover.
Turnover. Huh?
Turnover is much more. And here, my lord, only manufacturers can submit tender. That you all also have seen, I think.
Correct.
My lord, page 78.
Yes, yes.
Clause A and B. Only
Correct.
manufacturers.
No, no,
Contractors
reason is very simple because the requirements of clause L and Q, net worth is not less than 10 crore.
Yes.
And the turnover is also not less than
Turnover
10
is, my lord, I have complied. No.
What about the net worth?
Net worth up to more than 20 crore.
You have shown, you have
23.
submitted.
In 23. If 24 is taken, then it will be more than 30.
Yes.
But that they have not taken. They have asked for 23. Asked for 23, my lord, net worth. 23 it was 20 plus.
My lord, may kindly
No, that's what, just wait for that. You have shown your net worth is 20 crore.
more than 20 crore. He said more than 20
crores. And the turnover also more than 20 crores.
Yes.
Okay. Now this, as per the requirement of page 80,
80, yes.
Yes.
this is 10 crore, still not less than net worth of 10 crore.
10 crore, only 10 crore.
Not less than 10 crore.
And then Q, come to Q,
Yes.
not less than 10 crore.
Yes,
This is also turnover,
Well,
right?
Right.
Then please come to that, what is that qualification?
Page 98.
98.
They have, my lord, they have.
Yes.
They show.
These have to be determined only. That's all, nothing else.
Yes. This is the thing, my lord.
98.
90. Now, my lord, why this is required? Well,
Yes.
the court is, then court is required only. Why this is required?
Average turnover of rupees 10 crore each financial year for supply of so and so, so and so. This is also right. Then this serial number 8.
Yes.
Up to 20 crores, 5 points, then up to, it goes up to 35 crores, 20 points.
20 points. What
Now,
is the relevancy
now
of
this minimum points required for qualification in technical is 90 points. You explained this.
Yes, that is what.
Other day you tried to explain, but this code is not in,
My lord,
not convinced. So I request you to have a look on it.
my lord,
It's not
my lord.
tell you with the requirements. I mean, it appears to be not rational or reasonable. Because in one clause you say not less than 10 crores.
Correct.
Either for net worth or the turnover. Now you are giving a points up to 35 crores, right? And the total points which they will get is 100 points, right?
Correct.
If you minus this, see up to 20 crores, then 10, 15 and 25, nobody will get 90. Those who,
Well, he gets-
although they have
Well, he gets, as he
No.
submitted, my lord.
only 5 points.
No. As he submitted, my lord, his my lord, net worth is more than 20 crores.
Yes,
My lord, may kindly see, my lord.
up to 25 crores,
Yes,
10 crores.
up to 20 crores.
Yes.
Above means he's getting 10 points.
Yes,
Right, my lord. Now he said, my lord, his net worth is more than 20 crores.
yes.
Correct. Meaning thereby he gets 10 points. 10 plus 80 is 90, my lord.
No.
Yes, my lord. If you minus out of 100,
You just, huh?
if you minus out of 100, 20, then it remains 80.
No,
It's
no.
a simple arithmetic, my
No,
lord.
no, no. It's not like that. Total is 100.
Correct?
The person who is having a net worth of up to 35%, they get 20.
Maximum 20 is there.
Yes.
Correct?
Yes.
And minimum is 5.
Yes.
And in between, my lord, is 10 and 15 is there.
Yes.
Now, as he said, my lord, his network is more than 20 crores. Kindly note, my lord.
It's up to 25 crores. Is it 25 crores?
No.
Less than 25 crores. That means
Hello.
he gets 5 points only.
No.
I shall
Man,
get
no,
5 points.
no. Let us not.
See, up to
You'll
20
also
crores, 5 points.
You'll
Up to-
automatically read like this, my lord. Up to 20 crores, he gets 5 points. So after 20 crores, up to 25, he gets 10 points, my lord. So after 20, he gets 10 points, my lord.
Then
Then
10 plus 20 plus 15.
No, this is those who have, my lord, network of 30 crores, they get 15.
Yes.
The maximum is above 30, gets 20, my lord. So maximum mark is 20, my lord. Now out of, my lord, 100, if you minus this maximum number, remains 80. This is bothering your lordship, because if it is there, then no one will qualify. Right, my lord? Because the qualifying mark is 90, my lord. They have to secure 90.
Unless you get
Now here, my lord, the petitioner is getting, my lord, 10 marks,
10 points.
10 points, because his turnover is more than 20 crores, my lord.
Yes.
Right. Then 80 plus 10, he gets 90, my lord.
Then why he has been rejected?
My lord, maybe other grounds, my lord, not only this.
No, there is no other ground. There is no other ground. What is that?
And my lord, again, my lord, your
My
law,
lord-
clause 5 will see.
Eh,
States.
just-
My lord, I don't
just-
know, sir, why.
Now, my lord, so far, my lord, average turnover is concerned, my lord. My lord, average is average, that is not the total income, my lord. That is total, my lord, turnover, my lord. That is including, my lord, all the expenditure and liabilities. Now, what we short, my lord? As, my lord, they have said, my lord, 4 and 5, I think they are not rubbing on this point, my lord. What they are saying, my lord, only 8, the network, my lord.
No, 5 also, 5 also. 5 was not
Is
there,
it-
even minus also.
It's a average turnover. If your network is 10 crores, you can have more than 20 crores turnover. So there is no limitation, my lord. The turnover is your annual business. You are running a factory, my lord. You are running a factory, your annual turnover will be definitely more than 10, my lord. And my lord, the network, my lord. Network, my lord, not only the, my lord, the industry they possess, my lord. Other, my lord, the intake, excluding the liabilities they have, my lord. The financial credential of the present, my lord, firm, my lord. That's what we short, my lord. And so far, my lord, this qualification point is concerned, my lord. They have not said, my lord, how this is irrational. They are only saying the, my lord, 90%. My lord, these are the hyper technical issues, my lord. We are not equipped with. But this was done with a bona fide intention, my lord. So that, my lord, the supply chain of, my lord, needy to the children and women is not, my lord, suffered, my lord.
From where do you say, can say that how much points you have been given?
But that is, they've said in the 90 points not received.
Huh?
That is at, my lord, at page 103. Or that is why I rejected. The bottom
10.
minimum qualification point 90 could not be scored by the bidder.
103.
103.
Minimum qualification point, that is 90 points, could not be
Scored by the bidder.
scored by the bidder. Because if you agree that his net worth is 10 crore, and the turnover is also 10 crore. And if you agree that he has more than 10 crore, 20 crore, or up to 25 crore, then why you have not, why he could not score 90 points? If we agree, accept your submission.
My lord,
Because 90 is minimum.
My
Unless
lord-
you score 90,
90 is not only confined to my lord, paragraph 8, my lord. Right from 1 to 8, my lord. All to let this sequence, my lord. Overall, my lord, he has to score 90, not only complying with paragraph 8, my lord.
no rest or no issue, they will get
Ma-
it.
That's why they have said, my total average, my lord, he failed to score
Where
90.
is the score sheet? Let us see how you have given the point.
Point, my lord, we have not said, my lord, how this point has been given, my lord.
We'll have to find out whether how he has he could not
My lord, you lost,
score the 90 points.
you lost, may kindly come to again, my lord, 98, my lord. This is bothering us. The
Yes.
qualification point, my lord.
Yes.
Now, my lord, this serial number 8, the network, this is not only the ground for qualifying, my lord, because this carries only 20 points, my lord. What about the other point, my lord? Manufacturing license, 5 points. FSL certificate, 5 points. BSI, 5 points. Then average turnover, 5 points. Then supply of micronutrients, 25 points. Well, these are the criteria. Overall, my lord, average he has to secure 90, my lord. Now, what my other side is saying, my lord, they are only harping of 8. The network, my lord, network.
5 and 8. 5
All
is
right.
not, 5 is not there even minus also. The minus that the committee has not suggested for that.
Well, minus is different, my lord. Minus cannot be, my lord, is the ultimate, my lord, terms and conditions of any bid, my lord. Minus is the official, my lord.
This qualification points has to be submitted by you.
Yes,
Malam?
yes,
Yes, yes, other things are all right, Malam.
Where it is.
Except 5
Let us
and
see
8.
whether
Well-
you have submitted these points.
No, so far, Malam, except 5 and 8, I am qualified. Except 5 and 8. Except 5 and 8. 5, Malam, I don't know where from they have got it, Malam. The 1 state, 2 state. If my turnover is more, Malam, even then I shall be out. Why?
No, how you have submitted this? You have not submitted.
This 5.
Qualifying points.
No, qualifying
The
points.
forms of authorized signatory or company.
Yes.
This is to be submitted by you only.
Yes, bidders, my lord.
Yes.
Let us see where you have submitted.
Copy, my lord, that I have to, my lord. Copy, I have not. Let's hear, my lord. But so far,
It's gained significant because what he's saying is,
Yes.
suppose even if you are not getting, even if you get 20 points
Yes.
in clause 8 or then 25 points, you may
Clause
not,
5
you can be disqualified in
no,
other
but
points also.
other things they not said, my lord. Other things they have not, because these are eligibility criteria in the first tender also. So far, the other points are concerned. Other points are there in the original, my lord, tender.
But you have to submit.
Only 5 and 8 has been added later. Except 5 and 8, no, nothing was my lord, added later. Others are very much there, and I have to all satisfied.
Where is this? Let us see. You have to submit this. This is added by corrigendum.
This is the
5 and 8.
No, 5 and 8, my lord, this is the tender. They have, my lord, as per the this minutes, my lord, they have added. That minutes I have to place, my lord, and let's just see page 20 of the affidavit. That's my lord. They have suggested this 20 points for the.
No, there are two issues
network.
now.
Yes.
What they are challenging is that you could not have add this 4, 5, and 8. When you have a conditions in clause N, L, N, and
Yes.
Q. This is contradictory to that. It doesn't have any. It doesn't have a rational basis.
Yes.
This is what they are saying. Because admittedly, they may not entitle this under the 5 and 8. 4, 5, and 8, whatever.
5 and 8 only, my lord. 4 also not required.
5 and 8.
5 and 8.
Therefore, it's not rational. There's no rational basis.
Yes.
Number one. Number two, other point which from according to his submission, even if you may not get this entire points in 8 or 5, even if you get this,
Yes,
you may be rejected if you don't score 90 points.
yes.
For that, we need to look into your this point submissions which you are eligible or qualified in other clauses, other serial numbers.
That is the main reason, my lord, because we are challenging only the two clauses. Except that, my lord, we are qualifying.
No, understood. We have understood.
Yes,
But what they are saying is,
yes,
even if we read it down,
yes.
this clause 5 and 8,
That is why only I am saying, my lord.
and gives you this benefit of 25 to 20 points.
Yes.
In other clauses, I mean, serial numbers also requirements, so you may be.
That is only my prayer, my lord. I want
No,
that, my
no,
lord.
you are
because
not,
I will-
sir, you are, I think I'm not, you are not
No,
clear.
I understand, my lord.
What I'm on is,
Yes.
even if you are entitled for this 5 and 8,
Yes,
say 20 to 20, 45,
yes.
and then send some 10 or another 15
Other
or
full
16
I shall
points.
get. Others I shall get full.
That's exactly I wanted to know
Yes.
how you are fulfilled. If you are fulfilled, so you will examine, determine on that.
Because why I am submitting.
Have you pleaded that?
No, yes.
Have you
my lord.
given the response to that? What you have submitted in your affidavit?
Yes, sir.
My lord, in our affidavit, paragraph 14, 15 and 20,
1, 2 and 3.
yes,
1,
24,
2
my
and
lord.
3.
Because these are, my lord, legal point, my lord, that was not incorporated in the affidavit.
These are not legal points, these are factual points.
Textual points, my lord. Your lordship may kindly note one more thing, my lord. Now, page 80, wherein, my lord, the turnover is 10 crores. The qualifying mark also says, my lord, qualifying point also says, my lord, it's a 10 crores, my lord. There is no any
But you
difference, my
have
lord.
given advantage, that is why in their case.
So that is
Well,
If everyone is given the
That's why,
requirement
my
of
lord,
10
Puri-
crore, why you have added a points who is having a more than 10 crore and 30 up to 35 crore? That is exactly the precise point they have raised,
my lord,
which is not rational. There is no rational basis on it. Suppose you have provided 10 crore each for everyone.
my lord.
Why you should put more condition will give advantage to some persons who is having more than 10 crore net worth or turnovers.
Then, my
That
lord,
is called tailor-made.
then, my lord, how do we determine who is financially sound, my lord? Because it's a
cannot.
criminal.
You
Then how do we determine?
They must-
Well, these are the factors to determine, my lord, what is their turnover. Because for every company, my lord, their turnover determines the healthiness of
See,
the.
sir, there must be some rational basis. Suppose you are providing 10 crore, you are not, nobody can stop you to provide maybe 20 crores, 35 crores. You put that condition, but you have put a condition of 10 crores and adding some in another condition, you said those persons having 35 crore. What's the meaning of having a 10 crore, net 10 or 10 crore what? Or the turnover 10 crores?
May I just put it like this, Mala? Suppose a company having a net worth of more than 20 crores.
Yes.
Well, he gets 20 points.
Yes.
But he does not have the manufacturing license. Or suppose supply micronutrition, then sport, he does not get
No,
it.
according
He-
to them, it's all.
He lost
they
20
fulfill-
points, 25
they
points.
fulfill everything except 5 and 10, according to them.
My lord.
Except 5 and 8.
5 and 8.
5 and 8.
Because the
Now-
reason is very simple that in closed N you said, L you said, net not less than 10 crore net worth. And Q you said
It's a
turnover of
turnover.
10, not less than 10 crore.
Correct.
When this is the requirement, why you are giving advantage to person who is having a 35 crore net worth? Otherwise, in that case, you could have provided the manufacturer must have a net worth of 35 crores.
My lord, these are the just qualifying marks, my lord.
That's right.
These are the qualifying marks.
So you
They-
have disqualified them on the basis of these points only.
My lord, may kindly see, my lord. Again and again. Now this.
No, I have understood.
Yes,
Then
sir.
you have to
Now-
explain.
Paragraph 8, my lord, the carrying 20 points, my lord. 20 points. As he said, my lord, these 20 points, my lord, is not only the sole factor to determine whether he qualifies or not, my lord. There are others, my lord. Now-
This is their the assertion.
Yes,
Categorical assertion that except for 5 and 8, they are qualified.
qualified.
They are entitled for all the points. Therefore, they are before this guy.
Now this again, my lord, this qualification point, the serial number 4, the average turnover, exactly as mentioned in Q. The turnover is, my lord, 10 crores, my lord. Now turnover will not determine whether the healthiness of any industry, my lord.
Network.
Network, correct.
Network.
Correct, network. That's why, my lord,
Number 8, network. You said network.
correct, my lord. That's why, my lord, to check their financial, my lord, soundness, the mark has been given. If your network, you secure this mark. Because we get better security, my lord. It's a supply things. It's a food grains to the children, my lord, to the women, my lord. That is the main reason behind it. Otherwise, my lord, everybody will come, my lord. They will supply and they will break up. There will be break up in the supply of the food grains.
So you
Then
saw,
who will be sufferer,
in
my
that
lord?
case, you saw that he is not entitled for any other points other than clause 5 and 8. I mean, serial 5 and 8.
If that be so, that will be grossly prejudiced to respond number of those who have qualified, my lord.
No. That cannot be.
If any solace is given to my lord petitioner pertaining to 8 and 9, my lord.
Now,
my
this
will-
court would like to see how whether he is really entitled for points in other serial numbers except 5 and 8.
Yes, 5 and 8.
They are not challenging other serial numbers. 5 and 8 on the ground that actually it's very simple.
But
On the ground that it doesn't have a rational basis with that of the when you have provided in the clause L and
L.
Q.
Yes.
That's all.
Only my lord bothering is my lord L. Because here it mentioned my lord 10 crores network.
Yeah.
Yes, my lord. That is also my lord for a year, my lord, till 31/3/2023, my lord. Now, my lord, you lordship may kindly consider one thing. My lord, they are the product of this biscuit, everything, my lord. Meaning they are having a factory, my lord. Yes. If they have a factory, my lord, if they have license, my lord, that does not automatically qualify, my lord, that we should not put any terms and conditions. Why do we put terms and conditions? To secure ourselves, my lord, because it's a food supply. Because it is a centrally sponsored scheme. They may have to wait for 6, 7, 8 months, my lord, even for a year.
That's why a while ago I said, then why don't you put a terms and condition of why only 10 crore? Why don't you make it 20 crore or 25 crore, 30 crores?
That we sought,
See-
my lord, that exactly we sought in the my lord, network
No,
to show your my lord,
because
financial condition, my lord.
the persons who is having a network of 10 crores and turnover of 10 crores, they are all eligible. You cannot create another condition to give it amounts to giving advantage to those persons who are also eligible or over eligible, more than eligible. You cannot have that kind of stipulations. As you know, it's a level playing field will be given. Otherwise, if he doesn't have more than 10 crore, if the condition is 15 crore, 20 crore, they cannot say that you cannot put this higher amount. Suppose if you accept your argument to have a security for supply or manufacturing of the food items, you are asking for this much, right? It has to be given to them. If they are having only, if you have that 15 crore, if they have 10 crores, only net worth, they are not definitely eligible. But they cannot claim that why you have put in 15 crores. But since
Right.
you have put in 10 crore, it has to be in consonance or rational. There should be a rational basis on your condition itself. Otherwise, it will give an advantage to a person's. I would not say that they are blue-eyed boy or something like that. It will amounts to violation of level playing field.
fair play. No, this serial number 8, my lord.
Well, if you'll also see page 68, 69, we have supplied more than 23 crore to Assam and 22 crore to Khasi in same year.
It's okay. Let's do and then. I was interested to on your submission of this
Yes, sir.
qualification points,
Yes, 5
which
and 8.
obviously you have not
Only
done.
5 and 8.
I think you have not done.
Yes, 5 and 8. Other points, my lord, I have not.
You have not.
Other, yes.
This qualification you have not filed.
5 and 8, that is the my lord, main class. 5 and 8, my lord, they have added more. Otherwise, all the
See,
items
sir,
are
I
there.
think page 98, you
Yes.
need to submit these qualification points.
Yes.
Yes, during my technical base,
This
my lord, they have to
is
submit.
a kind of format only.
This is format, correct.
So you have to give remarks here. That
Yes.
is what I wanted to see.
Yes.
If you have done it,
That must be, my lord, but,
if you have submitted.
but I'm not.
No,
that,
this
my
is
lord.
your tender document because you have quoted the rate of the others and everything. Then you must have the knowledge, my
Do you
lord.
have the documents?
My lord, I don't have right now.
Can you produce?
Yes, my lord, it need be, my lord.
Because certain materials need to be looked into in the documents. Because it's a one line sentence. I mean,
Correct.
one line saying the rejection,
Mhm.
saying that he could not score 90 point.
Mhm.
Why they have not? He has not been. Neither they are able to produce this 98 qualification point format.
Yes, my lord. This
So
will
let
be the
us
part of the bid document. Obviously, this is a
We'll
format.
conclude. We'll keep it reserved. I mean, we'll conclude the hearing and we'll
I will
request him
produce
to
the record, my
the
lord.
records. As and when records is,
Yes.
then we'll.
My lord.
My lord, I've given the 4 list of debts books, my lord.
Okay. Just note it down.
Yes, my lord. I've given. Yeah.
May I lodge?
Yeah,
Lordship.
Yes, I can do.
Do we need to
No, my lord.
read it out?
No, no, need, my lord.
Huh? You got it?
You got it, no?
Okay. Note it down. Whoever is there.
Lordship, in item number 22 to 24, oral submission has already been advanced by
Yes.
senior counsel. Your Lordship, we may be allowed to file a written submission as well, Your Lordship.
It's up to you.
By tomorrow, day after tomorrow, we would like to file.
Are you sure that, are you apprehensive that this court may forget whatever you have argued?
No, Your Lordship. No.
It's better if you can, because you will be keeping it, making it a CAB.
Yes,
It's
Your
better
Lordship.
for the court,
Lordship.
convenient for the court.
Lordship. I'll file.
So that in that cases, we have already passed the order.
Yes, Your Lordship. Yes, already, orders dear,
What
but
is that?
since today,
Last
it is-
order, when is the last order?
last order is of 21/11/2024. Item number 22 to 24.
Okay, then we'll pass this.
Lordship.
Nobody is appearing for private respondent.
No.
No.
Service of notice.
Yes, my lord, they initially appeared, but they are left, left.
Heard Mr. G.N. Sahewala, learned senior counsel assisted by Mr. A.K. Sahewala, learned counsel for the petition in item 21, huh? Item 21. And also have Mr. Arich Nabam, learned additional advocate general. For respondent number 1 to 5.
Yes.
No, 1 to 4. 1 to 4. Non appears for the 5 is in other cases. Why 5 is there? Why 5 is there? Respondent number 5. His writ petition and other connected writ petition. Anyway,
They have not appeared.
non appears for respondent numbers 5, 6,
And 7.
and 7. Respect service of notice.
5 is 3.
Oh, you are for 5.
Yes.
Okay. MS. And Anju appears for respondent number 5. Non-appears for response 6 and 7, response service of notice. Huh? Hearing concluded, judgment reserved. In the meantime, no, once it is reserved, nothing. You may file your written argument. He is also filing. We are granting you by Friday.
Lodge.
By Friday. On the prayer of learned counsel for the parties. This is the matter on Friday, huh? Friday is 29 for submission of written arguments. I think you also file because you whatever you have submitted, it's not pleaded, it's not the part of your affidavit. Whatever law points only, and any clarifications you may submit.
You noted me all record my lord to production. of
Records.
Records.
The learned additional advocate general is also directed to produce the record on Friday only.
On Friday, my lord. Also direct the registry to give a copy so that I can communicate. That will be easier for me.
What's there?
Because it's a course order, my lord, to show them that the courts want to see the records.
Furnish a copy. Please furnish a copy to them.
Hardly this.
Learned additional advocate general of the order, huh? Well, Friday will list it only for submission and records. Then we'll see.
Much obliged.
In item
22 to 24.
Item 22 to 24.
24.
Or so and so. Same order. You are not party here.
No.
In Anju so and so, huh? Hearing concluded on so and so, huh? On the request of learned counsel for the petitioner, list the matter on so and so. Huh? Same day for submission of written arguments and the records.
Obliged.
I think should be listed before any other appropriate bench.
Junior, the impugn order passed by the civil judge, junior division is not maintainable at all. Basically on the non-registered the society move civil judge by way of title suit as well as along with the miss case. So unregistered society cannot maintain cannot be sued or be sued. That is the first round of first limbo submission. This is purely a student election, wherein the sole respondent has filed a civil suit before the Land Court below.
This is by whom? Filed by whom?
Filed by, my lord, the impugn order was filed by, my sole respondent, Sri Ramesh Maga. And my lord, now civil revision before your lordship is the so-called, my lord, the constituted election commission.
So why you are saying that they are not registered body?
Yes,
Cannot maintain civil suit?
yes, ma'am. They are not maintained. This, my lord, the organization is not a registered organization, my lord, therefore, my lord, it is not maintainable, my lord.
Only student union.
Yes, ma'am. Yes, ma'am. All Nishi Students Union is a student union body constituting, my lord, the members from only the Nishi community. And it is not registered, my lord, organization, ma'am. So only basically
So
on
that's
that.
why civil suit is maintainable. It's not necessary. It should be a registered body.
My lord, registered body, my lord, that can be, my lord, possible.
Where is the array of parties? Let us see. Where is this civil suit?
Civil suit, my lord, I have not enclosed, my lord, impugn order. And
Title suit, title suit.
title suit, I'm sorry, my lord, that I have not enclosed.
What is the this is injunction?
Injunction, my lord. Injunction granting, my lord, expulsion was given, my lord.
What is this? What do you mean by this? 9/4/24 is what? What notification?
My lord, notification for the election, my lord. This is
And so
notification.
the expulsion order 11/9/20 issued by the respondent number 7 is ever suspended for orders. And notification 9/11 election final list of candidates issued by residents were suspended with respect to instant petition.
Madam.
So
my lord, another limb of submission is already, my lord, the election.
who are you?
My lord, we are the, my lord, the constituted, my lord, the commission for the conducting this election, my lord. We are the members, my lord, who is authorized to conduct, my lord.
After this order, what happened?
16 general conference come election.
What happened?
After this, my lord, the counting process was already started. And counting is almost over now. Oh, sorry, my lord. Voting process was, my lord, when the order, impugn order was passed. By that time, my lord, already the voting process was started. And in between, my lord, this order has been passed. And because of which, my lord, the candidature, my lord, the sole respondent has been also put into the list of
allowed to contest.
Allowed to contest. Earlier, he has been declared as the unelected, my lord. One candidate who is opposing this post, my lord, has been declared as elected uncontested, and thereafter subsequent order, by this order, my lord, that another person has been, my lord, allowed to contest in the voting process was already over, started. Now counting is going on at this stage, my lord.
So he has also contested.
Yes, he has contested.
Voting has been done.
Voting has been. He has contested, my lord.
We'll see on next returnable day. Because it cannot change, we cannot take it back. Even if you stay this, it's already over. He has been allowed to participate.
But my lord,
we just cannot throw him out now.
correct.
So we'll see. We'll issue notice. We'll see next day. If we suspend this, again we'll have to take him out. So once that on this is in view of this order, voting has also already taken place.
Completed.
He has participated. Counting is on.
Yes,
is not it.
Completed. Now counting is now, my lord, as per the information is received from the, my lord, the client. Now the voting process, my lord, counting process is going on, but in respect of counting in respect of these two candidates is not, my lord, taken place. My lord.
No,
it has been hold. It has been put on hold. My lord.
No, it cannot.
Along with the other party.
No, once he has been allowed to participate, contested, and voted.
True, my lord.
If the voting has already over, counting you cannot stop. Right? This was passed on when?
21st November, my lord. By that time, already voting process was started. Altogether, my lord, more than 200, around 300 voters have casted their votes. In middle of the, my lord, this order has been passed, and by virtue of this order, my lord, he has been allowed to contest. So many infirmities in the order passed by the learned court below. There are.
You come up with You have some, do some research again on the issue. We'll decide on next step. All right.
Well,
But we'll not establish. No intermodal will pass.
Malat, in that, Malat, in such situation, Malat, the counting may be, Malat, put on hold, Malat.
No,
Result may not be declared.
this is post of what? Post
Vice,
of what?
Vice President, Malat.
It would not be proper. When you take the analogy of the panchayat and the state and general assembly, election process, let us not install this. Let it go. It will be subject to that.
Election, Malat, voting, everything has been done.
Because-
Only the counting is going on in respect of, Malat, so therefore, Malat, may I feel that, Malat, the counting in respect of this post may be put on hold, Malat.
Not put
Till the tenable one.
Have you filed your the response there, written statement there?
No, Malat.
Are you a respondent there?
Yes.
Defendant there?
Yes, yes. In civil suit,
I
Malat,
just
we are the
wanted to
party.
see the array of parties.
And so many
Heard
interpretations.
Mr. M. Katlan, counsel for the petitioner. Challenge made in this revision petition is to the order dated 21/11/2024, passed by the Civil Judge Junior Division, UPM, whereby passed by the Civil Judge Junior Division, UPM, in miscellaneous within brackets J bracket clause case number 22 of 2024, entitled suit number 18 of 2024. Whereby the expulsion order dated 11/9, expulsion from where?
Expulsion from the membership, Malat.
Expulsion from the membership of all the student union.
Yes, Malat.
Dated 11/9/2024, and the notification dated 19/11/2024, relating to final list of candidates for, is issued by the your petitioner.
Yes, Malat.
Your petitioner here, respondent number 1, there is.
Sole respondent only.
You are petitioner here.
Respondent, sole respondent, Malat, is the respondent in this, Malat, in this civil division.
No. Can it issued the notification, final notice issued by whom? Respondent number 1 in the title suit? In which case?
Yes, Malat.
Are you a petitioner here?
Yes.
Who has issued the final notification?
Malat, notification issued by the Malat, petitioner number. Malat, it is given, Malat.
Issued by the respondent.
Petitioner number.
Petition number?
5, Malat.
5, no?
Yes, Malat.
Number 5 has been suspended. Issue notice to the respondents, returnable by 2 weeks. Mr. Leland counsel to the petitioners to take steps for service of notice upon respondent number. For all the for respondent number. Okay, respondent, sole respondent.
Malat.
Sole respondent. Next paragraph. Hard on the interior. Interim prayer will consider next. To relate the STMP order passed by the so in the title number 18 of We'll consider the interim prayer on next date.
There is also KBL in the cause this month.
Caveat.
KBL, Malad.
List it tomorrow in that case. Since I'm not inclined to pass interim order. Because reason is very simple that by the, it has been implemented in fact. Why now? Because the title suit will decide, right? Whether that was wrong or right. The interim order that has been suspended and he has been implemented. So it will be,
In that
I
case,
mean,
Malad.
futile.
Yes, Malad.
To say that.
In that case, Malad, may I phrase it, Malad, the counting in respect of declaration in respect of this post may be kept in Malad, AVN, Malad. That Malad, the order, Malad, in the interim, Malad, that declaration of result for this particular post may be kept in AVN.
Caveat is there.
Yes, Malad. Caveat, Malad, petition has been filed.
Have you served a copy?
In fact, Malad, as I am informed, they are not available in the court
You
premises.
serve a copy. We'll take it up tomorrow. All right. Caveat is there. They have not served a copy.
I mean, for Malad, they refuse to receive the copy of the Malad, the copies are to them, Malad. Caveat. They refuse to Malad accept the copy of the Malad petition, Malad. Caveat, Malad.
In that case, heard on interim prayer. Considering the petitioner. No, respondent has been, after passing of the impugn order, the respondent has been allowed to contest and considering the fact that the petitioner has been, respondent is informed by the counsel for the petition that the petitioner has already been allowed to contest the election after passing of the impugn order dated 21/11/2024.
Well, the respondent has been allowed to
contest. Respondent has been allowed to contest in the election of the said students' union. And the counting of voting should yet to be completed. Counting of the vote is under process. The result of the election, the result of the election in respect of the post of vice president.
Well,
in respect of the respondent shall be outcome of the present revision petition. We'll just say outcome.
Deep level.